Well, hello, everyone, and welcome to Uncivil Law. I hope you're having a great day, and we tune in to the Karen Reed trial once again on April the 3rd as jury selection continues underway. It is my understanding that we've selected 10 jurors, I believe, as of yesterday, which was a nice little pickup of pace. On day one, we only got 2, and apparently yesterday we got 8 more. So maybe this jury selection will not be as long as we had anticipated. Maybe it will be done this week after all, which would be pretty good if they can get it done that fast. I have no problem with that. If they can get it done that fast, that sounds awesome. We also apparently are in a different courtroom, and only fan is now black, which is also very exciting. Black only fan. I notice also that this ceiling is far more interesting with its, what would we call this? The patterns in between the wall or the beams. Like each one looks like they're slightly different patterns, or at least alternating patterns. So this appears to be probably a ceremonial courtroom, which, you know, that's cool. But we have elevated things, and if you notice, sort of on the back left, in the sort of bottom left corner of the image, in the bottom left corner, you get a little bit of some wall art there too. That looks like it's carved into the wall. That's pretty cool. I'm not gonna lie. So that's pretty exciting. Also, we might have a motions hearing this morning, which is one of the reasons I'm broadcasting it, because I hear tell that we might get a decision potentially relating to witness exclusion this morning. I'm not sure which of them moved. I think it was the defense. I'm not sure. Anyway, one of them has moved for the exclusion of all the witnesses from the trial, including even after they testify. Now, segregating the witnesses before they testify is pretty standard procedure. We've seen it not done. We've seen it in the Murdoch case. For some reason, it was not done, which was really, really weird to me. But it's pretty standard procedure to not let the witnesses see each other testify. But it is a little bit more unusual, although not unheard of, to prevent them from entering the courtroom once they're done testifying, because at that point, they're just members of the public. But of course, the defense, at least with respect to some of the O'Keefes and some other people, the Alberts, people relating to the Alberts or people relating to the O'Keefes, believe that there might have been some intimidation by those police officers being there and glaring at the jury. And we had some affidavits from some of the former jurors apparently saying as much. So, you know, I don't need a lot to convince me as a judge to exclude them, because the right of the public to attend the trial is a collective right. It's not an individual right. So that while the public has the right to attend a public trial, that right does not extend to any particular person. And so the judge can pretty much exclude, the judge can pretty much exclude any individual person for any non-protected reason. So as long as they're not doing it because, you know, they're black or because they're a woman or because of something like that, you can exclude pretty much any individual person from the courtroom, you know, basically in the interest of justice, which is basically infinite latitude. So you don't need a lot to convince me. I'll be like, well, why am I doing this? And be like, oh, we're concerned about intimidation. Why? Oh, in the previous trial, one of the jurors had said, oh, they felt intimidated. I'm like, sold. You know, you don't need a lot to convince me. But what will Judge Bev do, of course, is the much more interesting legal question, or maybe not necessarily the legal question, maybe it's the practical question, right? Because what was the practical question? What will Judge Bev do? Who can say? Of course, one of the benefits of kicking all the witnesses out is, I believe, Aidan, Turtle Boy himself, is listed as a witness, which means despite his media pass, he would not be allowed to attend the trial, even if he's never called as a witness. So Judge Bev would be able to exclude Turtle Boy from being part of any part of these proceedings or being in the courtroom, despite the fact that he's a media pass. Like, no, I'm kicking you out because you're listed as a witness, don't you know? Yeah, so that sounds like something she might do. And if she's gonna do it for Turtle Boy, Why not do it for everybody? But of course, only Judge Bev knows for sure. Yeah, someone pointed out that the cube right next to the fan is blank. I'm not sure what that's all about, but oh, and there's a white fan in the background. I didn't even notice before. Yeah, okay. It's just kind of very softly spinning. Let's see if I can make it so you can see it, because you can't see it right now. And I don't want you to be deprived of any fan time. Why are my margins not quite working today? Yeah, it's not off by much, but you are just missing a little bit of the screen. And I'm having trouble adjusting it so that it's perfect. No, I got it, sort of. Okay, this is closer. All right, so now you can see the bottom of the white. It appears to be a white fan spinning in the background there. You know, for as nice as that ceiling is, I have to say that I'm not really as impressed with the courtroom itself. I think it's that bookcase is just not working for me. I think maybe the furniture in the courtroom needs an update or something. The furniture doesn't quite feel like it has the same majesty as the...
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. God hear, if you're attended, you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
And also this big black...
Stand and raise your right hand one more time.
This big black like thing that's next to the prosecution table, which I assume is some sort of media player. It holds like the, DVD players and such. There's got to be a better way of hiding that. It's just like a little bit of an eyesore.
May I call the case, Your Honor?
Please.
Your Honor, this is docket number 2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
May I introduce myself, Your Honor?
Please.
Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts.
How you doing, Hank?
Along with two of my colleagues.
Good morning, my name is Lauren Laughlin. I'm the Assistant District Attorney for the Norfolk.
What's up, Lauren? Holla.
Good morning, my name is Adam Allen, Assistant District Attorney with the Norfolk County.
Hi, Adam. I kind of wish you were still lead prosecutor, to be honest. Please come back. Please come back.
And then counsel for the defense.
They say you never know what you had until it's gone. Please bring back Lally. Hashtag free Lally.
Good morning. My name is Alan Jackson. I have the privilege and honor to represent my client standing to my right, Ms. Karen Reed.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning. My name is Robert Alessi. I likewise have the privilege of representing Ms. Reed, and I thank you for coming today.
Good morning. My name is David Iannetti. I'm an attorney. I have offices in Boston and right here in Dedham. And it is truly my pleasure to represent Karen Reed.
Good morning. My name is Victoria George.
Victoria!
And I have the privilege of representing Ms. Reed. And thank you for being here.
Victoria! The juror. It's Victoria.
Thank you very much.
Victoria gets a
Ms.
theme
Reed,
song.
can you please remain standing for just a moment? Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your trial. If you'd object to any of them, you must do so before they are
Wait a
sworn.
second.
You have a right to challenge any 16 jurors without giving reason.
Why is the
Thank
clerk reciting this?
Good morning, jurors.
That's odd. Why is the clerk announce that?
And I want to
I
welcome
don't know.
you
That's
here
odd.
today
All right.
and give you some idea on how we think your day is going to shape up. So I just want to say before we start that Jury service is certainly one of the most important civic duties we have, and as a civic duty, it does cause us to be inconvenienced. So we do appreciate that you're here, ready, willing, and able to serve if called upon to do so, and our system of justice simply won't work without you. So
Or
we
even
do
with you
appreciate
sometimes.
being here, and we appreciate your patience. So today we're selecting a jury in the criminal case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. On the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was later pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent, and she has pled not guilty to the indictments. So the defendant is charged with second-degree murder. She is also charged with manslaughter while operating a motor vehicle under the influence of alcohol and with leaving the scene after causing personal injury or death. I'll describe these offenses in greater detail at the end of the case when I teach the jury the law. But briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted
She has this all written down.
all theories it believes.
This is going to be literally word for word the same we heard the other
Commonwealth
day.
alleges that the defendant committed murder and that that murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the
I
end
wonder
of
what the
case
difference between
before you
wanton
begin
and
your
reckless
deliberations.
is.
Now,
Wanton or
at the
reckless? What's the
outset,
difference between
I would
wanton
like
or
to address the
reckless?
issue of public interest in this case.
Is there a
and
difference
the
between
duty of
wanton
this
and
court
reckless?
to adhere to the rule of law. John Adams said that we are a government of laws,
I'm not sure.
of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence in the courtroom at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is
Wanton,
contested,
merciless,
they will
inhumane,
determine where the truth
having no
lies.
just foundation or
Ultimately,
provocation, malicious.
The jury will decide whether the Commonwealth has
So it
carried
could
its
be
burden of
malicious.
proving that the defendant is guilty of any crime beyond a reasonable doubt.
Lewd or
People outside
brawdy.
of this building
Ooh.
have rights, and we know that they have voices. But
Playfully
this
mean or
criminal trial
cruel,
will be
hard to
decided by
control.
an independent jury, free from outside interference, based only upon the evidence presented
All right,
in this
there is a bit of a
courtroom
difference.
and
All
the
right.
law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask questions to you all as a group. and then
Done,
I'm
shown,
going to ask you to
used,
fill out a
maliciously or
supplemental questionnaire.
unjustifiably.
We have found that the use of this questionnaire is helpful for several reasons.
Deliberate and
First,
without motive or
there are some
provocation,
personal
uncalled
questions on
for,
it.
headstrong,
And we ask
willful,
that you be
without
candid.
regard to what's
In
right, just,
addition,
or
in the
humane.
process of filling out the questionnaire, you're provided
All
the
right, so
opportunity to be
it can
more reflective
imply-
as you answer the questions,
it can
rather
imply
than being put on the spot
Desire,
and
where
asked to
recklessness
give
doesn't necessarily
immediate
imply
answers.
desire. Fair enough.
After you fill out the questionnaires, we'll have you come up to the
Neat.
sidebar one
Vocab
at a
is
time
fun.
so that we can follow up on your answers to the questionnaire and to questions I will have of you. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you're not selected for jury service on this case, please don't take it personally. Don't think that somehow you're not a fair person. It's not a reflection on you at
It might
all.
be a little bit of a
You will be
reflection on
directed
you.
back to the jury room and perhaps
It
picked
could-
on a case.
it could be a little
different case
reflection
from
on
another
you.
court.
But don't feel
In a
that
few
way.
minutes, I'll pose a number of questions to you as a group, and you've just taken an oath that requires you to truthfully answer these questions and all questions put to you. If your answer is yes to any question, I will ask you to raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer may read the numbers from the card. You don't have to get the numbers out now because it will still be a few minutes and I'll let you know. The fact that you answer yes to one of my questions does not mean that you're automatically disqualified from serving on this jury.
The
We
sirens.
hear ambulances and fire engines going by every day, many times during the day.
We sure do.
If you're selected as a juror in this trial, we'll be seated in the courtroom across the hallway where we'll hear it even more.
Oh, exciting.
Generally, the lawyers stop and I stop talking when we hear it, so.
The sirens
If
are
you find
calling
a
us.
question that I pose to the group is overly intrusive, you can elect to answer that question at sidebar. And I'll probably have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror, and the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer. All we're looking for is your best, honest answer to the questions. Now, I have a witness list that I'm going to read to you. And
Read it
is
to
very
us, Bev.
lengthy.
Read it to
It
us.
doesn't mean that all of these witnesses will be called as jurors, but you will likely hear about these
Now
witnesses.
let's see
So
what order
I
it's
ask that
in.
you listen
Because someone said
carefully because in a
alphabetical
few
by
minutes I'm
first
going to
name,
ask you
but I
if
wasn't
you
necessarily
know
sure
any
even
of
that
these
was true.
witnesses.
So let's see if it's alphabetical even by first name.
But it's alphabetical according to first name.
Okay.
So, Aidan Kearney
Hi,
from
Turtle Boy.
Jefferson, Massachusetts. Dr. Isaac Wolf from South Miami, Florida. Alfred Lopalato from Canton. Allison McCabe from Canton. Andre Porto from the Massachusetts State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler, PhD from Pittsburgh, Pennsylvania. Excuse me. Angela Malvone from Canton, Mass. Annie Chung from Canton. Anthony Flamati from the Canton Fire Department. Ashley Bell from Canton. Ashley Villier from the Massachusetts State Police Crime Lab. Brian Albert, Norwood. Brian Albert Jr., Boston. Brian Higgins, Sandwich. Brian Loughran, Canton. Brian Wanless, who is retired from the Canton Police Department. Bridget Meehan, who is a keeper of the record.
Keeper of the
for Canton.
records.
Caitlin Albert, Easton, Mass. Lieutenant Charles Ray of the Canton Police Department. Police Chief Helena Rafferty of Canton. Chris Van E., who's a PhD from Novi, Michigan. Christina Hanley from Massachusetts State Police. Christopher Albert, Canton. Christopher Curran, Canton. Colleen Crawford from the Norfolk County District Attorney's Office. Colin Albert, Canton. Courtney Proctor, Canton. Kurt Roberts, Canton. Daniel Whitley from the Canton Fire Department. Daniel Wolf, PhD from Penns Park, Pennsylvania. Derek Ellington from Wake Forest, North Carolina. Dr. Marie Russell from Los Angeles, Dr. Elizabeth LaPosada from Providence, Rhode Island, Elizabeth Proctor from Canton, Eric Hanlon from Canton, Erin Beatty from Canton, Erin O'Keefe from West Bridgewater, Francis Walsh from the Canton Fire Department, Garrett Wing from Green Cove Springs, Florida, Gary Fowler from Brockton, Gregory Woodbury from the Canton Fire Department, Gretchen Voss from Boston, Hannah Knowles from the State Police Crime Lab, Heather Maxon from Walpole, Herberto Hernandez from the Boston Police Department, Holly Price from Mountain View, California, Ian Whiffen from Vienna, Virginia, Dr. Irene Scortabello, who is with the Office of the Chief Medical Examiner, Massachusetts, James Crosby, who's a PhD from Jacksonville, Florida, Jason Becker from the Canton Fire Department, Jean DeMoulis from Canton, Jennifer McCabe, also Canton, Jessica Hyde from Bridgeport, New York, John O'Keefe Sr. from Braintree, Judson Welcher, who is a PhD from a company called Aperture LLC, Julie
Aperture
Albert
Science.
from Canton, Julie Nagel, also from
We do
Canton,
what we must
Dr.
because
Justin
we
Rice
can.
from South Weymouth.
For
There are
the
two
good
juveniles from
of
Canton,
all of
one
us,
whom's,
except the ones who
initials
are dead.
KF, and the other PF. Caitlin Boudreau from Raynham, Karina Kolakathis from Canton, Katie Camarano from Canton, Katie McLaughlin from the Canton Fire Department, the keeper of the records for Ring from Hawthorne, California.
Keep off the
Kerry
records.
Curran from Canton, Kerry Roberts, also Canton, Kevin Albert, also Canton, Kevin O'Hara from the Massachusetts State Police, Lance Mello from the State Police Crime Lab, Laura Sullivan from Pembroke, Laurie Cahill from Worcester, Leslie Pearlstein from Canton, Lieutenant Michael Lank from the Canton Police Department, Louis Jutras from Canton, Lieutenant Brian Tully from the Massachusetts State Police, Lieutenant John Fanning, also State Police, Lieutenant Paul Gallagher from the Canton Police Department, Maggie Gaffney from Bonita Springs, Florida, Mark Lopalato from Canton, Margaret O'Keefe from Canton, Marietta Sullivan from Pembroke, Mary Souza from Dighton, Matthew Amory from Canton, Matthew DeSogra from Charlotte, North Carolina, Matthew Erickson from Grosse Pointe Farms, Michigan, Matthew Kelly from the Canton Fire Department, Matthew Kelsch from the FBI, Matthew McCabe from Canton, Maureen Harnett from the Mass State Police Crime Lab, Megan Mariani from New York, Michael Camarano from Canton, Michael Easter from Los Angeles, Michael Trotter from Canton, Michael Wagner from Foxborough, Mike Maroli from Bridgewater, Mike Rushworth from Thompson Station, Tennessee, Natalie Weewick Berschneider from San Marino,
Natalie
California.
Weewick Berschneider. What a
Nathan Reed
great
from
name.
Raynham, Nicholas
I
Bradford
like that
from
name.
Lorton,
Natalie
Virginia,
Weewick
Nicholas
Berschneider.
Curran
Wow,
from
that's
West
awesome.
Roxbury, Nicholas Kolakethis from Canton, Nicole Albert from Norwood, Norfolk County District Attorney Michael Morrissey, Officer Kelly Deaver from the Boston Police Department, Officer Nicholas Barros from the Dighton Police Department, Patrick Haggerty from Somerset, Paul Mikowski from Melrose, Paul O'Keefe from Canton, Rebecca Bison from Canton, Rebecca Trayers from Norfolk, Mass., Dr. Renee Stonebridge, also from the Office of the Chief Medical Examiner at Boston, Richard Green from St. Pete Beach, Florida, Richard Donatino from Canton, Robert Gilman from Hull, Ryan Nagel from Canton, Sarah Levinson from Canton, Sergeant Brian Gallerini from the Needham Police Department, Sergeant Sean Good from the Canton Police Department, Sergeant Paul Giampetro, from the Canton Police Department, Sergeant Yuri Buchanan from the Massachusetts State Police,
What happened to alphabetical
Shannon
order?
Burgess from South Lake, Texas, Cheryl Waugh from Canton.
We went to S and then we
Sophie
went to P and then
Herzog
back to
from the
S. What
Massachusetts
happened?
State Police Crime Lab, Stephanie Devlin, also from the Crime Lab, Stephen Mullaney from the Canton Police Department, Steve Nelson from the Norfolk DA's office, Stephen Bernstein, who's a keeper of the records. in
Keeper of the
Stoughton,
records!
Stephen Ridge from the Boston Police Department, Stephen Seraph from the Canton Police Department, Stephen Scanlon from West Roxbury, Terry Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty from Canton, Thomas Kelleher from Canton, Thomas Martin from Weymouth, Timothy Nuttall from the Canton Fire Department, Tristan Morris from Easton. The following are Massachusetts State Troopers. Tristan Morris is from Easton, Mass. Trooper Connor Keefe, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Kostkowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor.
Michael Proctor is
Trooper Nicholas
former
Guarino,
trooper, if you don't mind
Zachary
very much. Judge Bev,
Wendell Robery from Canton, Mass. And William
I thought you
Reed
respected the
from
law,
North
Judge
Dayton,
Bev.
Massachusetts. I appreciate your patience in listening to that list. There are a lot of people, so obviously this trial is going to take a while. We've already begun our impanelment process. We will continue to impanel. We don't know how long that's going to take. As soon as we start the trials, the lawyers tell me that their best estimate is that the evidence in this case will take 6 to 8 weeks. That's an estimate. It's a good faith estimate. We do the best we can to let you know in advance how long we expect something to take. It may go a little longer. It may go a little shorter. If you're selected as a juror, I will let you know at the end of every day. It's my practice to let jurors know where we stand, if we're on schedule, if we're behind schedule, which I can tell you has not happened, or if we're ahead of schedule. So I let you know every day where we are. That's the best we can do, and it's a good faith estimate. We just want to give you as much information as we can in advance, as much as we can. We expect that the case will go from 9 o'clock to 1 o'clock every day. We'll take a break around 11 o'clock for 15 or 20 minutes or so. Lunch will be provided to you. We're trying to take advantage of your time here with us. So rather than break for an hour to go out for lunch, which usually turns into an hour and 15 minutes or longer by the time we get things set up, we want to keep you here for a lunch break. We'll provide lunch for you, and we'll continue to move the trial forward throughout the day. The afternoon will go from 2 o'clock or so, or right after lunch, maybe 1:30.
Sure, we can use that as the keeper of the records emoji. Why not?
There'll be some days here and there that we won't be in session, and there'll be a few more days that we'll do half days, just morning. So we'll let you know in advance those dates. And again, that's the best we can tell you now. So it might help you if I also give you a preview right now about some basic law that applies to criminal cases like this. As I've said, it's my job to teach the jury the law, and I don't do that completely until the end of the trial.
Or
so
really
now,
ever,
I'll give you a
to be
brief
quite
summary
honest.
of some of the very important legal principles that will govern this trial. First, and most basically, Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a person of a crime in order to bring that person to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove his or her innocence or to produce any evidence whatsoever or to do anything other than attend the trial. This presumption of innocence remains with the defendant until the jury make your determination after you listen and consider all of the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, you accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word. A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. Now that brings me to reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, but it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in the case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the
It's not
evidence
supposed
must
to be
convince
enough.
you of the defendant's guilt to a reasonable and moral certainty. A certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Now, of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making your mind up before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in the case, consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law without sympathy, bias, or prejudice to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you have heard the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all jurors will have to apply the law.
I just want to state for the record that I heard basically a rumor there might be a motion hearing this morning, and that's the only reason I'm streaming this. because
these
I
legal
knew it would be
principles.
word for word exactly
So
the
go ahead
same
and take those cards out
as
because
the
I'm going to
previous.
start
There's
asking
no
you those
reason to tune into
questions.
this. It's going to be the same every single day. It has to
Before
be
we
the same
begin,
every single
I
day.
understand that sometimes jurors do not fill
So
out
the only
juror
reason I'm streaming is because I told there
completely.
might be a motion
Sometimes we're
hearing.
in a rush to get those
I feel
forms back in,
deceived.
or sometimes we think that maybe
I'm not sure who to
our
blame for this, but I'm
experience,
blaming
doesn't
somebody.
apply to the question that's asked. So when you come up to sidebar, if we see that something's missing, sometimes people forget to put in a work experience. Many times people forget to put in their age, and we do ask about that. We need that for purposes of this impanelment. But sometimes people forget to put in whether they were a witness in a case that was in court, a defendant, another litigant. So if there's anything that's missing, we'll ask you, but if you know that you didn't put something on there, please let us know at sidebar. All right, so if your answer is yes to any question that I ask, please raise your hand until the court officer reads your number. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names you heard?
Juror number 343, 360, 347.
So yeah, every day is a new group of jurors, right? They bring them in like 90 at a time. I don't know if that's the right number, but let's say it is. They bring them in 90 at a time. And so every day for the new group of 90, she has to give the speech again because obviously the other, they haven't heard it yet. And it has to be the same because every group has to get the same speech because otherwise it might be legal error. So there's no reason to watch it again because it's literally the same.
Juror number 312.
Okay. Thank you. Do any of you folks or close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or the Norfolk County DA's office?
Juror number 326, juror number 328.
But I was told there might be a motion hearing.
Thank
But
you.
I'm pretty confident at this point motion hearing is not happening.
Do any of you folks or a close personal friend or family member have any
Because the motion hearing would have
financial or
happened
other
first.
personal interest
There's no reason to
whatsoever
give the speech and
in
then
this
do a
case
motion hearing.
or
That makes
its
no
outcome?
sense. Or I suppose they could do the motion hearing at the end of the
I see
day.
no affirmative responses.
But either way, we've been
Please
misled.
raise your hand if you have seen, heard, or talked about this case.
I've seen, heard, and talked about the case. I have thoughts.
Juror number 319.
I have notes.
Juror number 317, 352, 353.
I know you've been a judge sworn in this particular state for quite a hot minute, and your specialty is criminal law, and you were previously a criminal defense attorney, but I still feel like I know the law better than you in some ways, which is one hell of an arrogant statement by me, but yeah.
326, 339.
Juror number 330. Juror number 357. Juror number 321. Juror number 333. Juror number 351. Juror number 344. Juror number 348. Juror number 361. Juror number 341. Juror number 310. Juror number 340. Juror number 334. Juror number 338.
No, I didn't. Well, I did one. But the closest I came to a criminal case was I did one reckless by speed in Virginia, which is a first-degree misdemeanor. So technically, I have done one criminal case.
Juror number 312. And juror number 359.
So yeah, I have lots of experience.
329.
All right.
Also,
Thank you
it's an
very much.
immediate plea deal, so it wasn't much of an experience.
Please raise your hand if you
I
have
literally
expressed
represent the
or
guy and we
formed
settled
any
5 minutes
opinion
later.
with respect to this
So,
case.
but yes, I've done one criminal case, lol.
Juror number 319, 353, 311, 343, 347, 354, 322, 326, 339.
Juror number 330. Juror number
Can I say what the punishment was?
Juror number
I don't remember. I mean, we pled it down to simple speeding.
Juror number 361.
We played it down to like under 20 miles an hour, and whatever the associated penalty with that would be, $500 fine. Maybe there was some class he had to take. I don't remember, but it wasn't a criminal conviction, which is what we wanted, right? So it was reckless by speed. So it was more than 20 miles and over the limit, or more than 80 in Virginia.
Are any of you aware of any bias?
So I was like, can we plead it down? Can we plead it down to just a speeding infraction?
It's
It's like, sure. We're like, great. I'm happy. Let's move on.
Either of the parties, please raise your hand.
Juror number 326.
How's my day? My day is excellent
354.
so far. I feel really good.
319.
And it might be placebo, but I bought some multivitamins, and I had my first multivitamin yesterday, and I feel fantastic this morning.
Hearing or any problem with understanding the English language, or any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict. Could you please raise your hand if you do?
Also, interestingly, this is really interesting. Just like as long as we're talking about things. So I did labs for my testosterone, and even without supplementation, my testosterone is actually like really good. So I'm like really confused right now.
Please raise your hand if you think you will have
like,
any difficulty following
the number shouldn't be that good.
Important constitutional
It's like, why is my number this good?
to you.
So I'm very
First,
confused.
that the
So I'm not sure if
Commonwealth
losing
has the
weight has like
entire burden of proof
somehow
in
helps
this
my
case.
testosterone or something, but
Second,
like
that
my
that
numbers are
burden of
actually
proof is
like
proof
pretty
beyond a
good.
reasonable doubt and
So,
to a moral certainty.
that was
And
confusing
third,
to me.
That the defendant is presumed innocent and does not
So I'll do
have to
labs
do
again in a
thing
month and see what
other than sit
happens,
in
but
that
it was
chair for
weird.
the trial. Would anybody have any difficulty applying those very important constitutional principles? If so, please raise your hand. I see no affirmative responses. I can tell you folks that after every jury trial, I talk to jurors, and though they may not have been thrilled about having jury duty, they always tell me that they have
Why shouldn't
found the
my numbers be
experience
good?
to
Because
be
my numbers previously
a
were
very
shit.
Interesting one.
That's why I was
and often
surprised.
jurors tell me that they
My numbers
find
were
it to
previously
be a
shit, and I
very
was taking
rewarding
TRT.
one. But I do understand.
And then I
that
didn't
with
take
this
TRT for
case
like 2
and
weeks, and I did
schedule,
labs, and my
it
numbers were
may
actually
be
really
an
good. I'm like,
undue hardship for
this confuses
some
me.
of you. Let me tell you what I mean by undue hardship. When I told you earlier that all civic duties cause us some inconvenience, an undue hardship or a substantial hardship is much more than that. It's something that means that it's personal to you.
Yeah, I'm
and
taking the
person
win. It was
sitting
just
next to
odd.
you will then have to step in.
I'll take
and
the win.
give
It was just
time
odd.
from their lives. I generally think of it in terms of either you're a student or you have airline tickets or surgery scheduled for the time that we will be on trial. So with that in mind and that very rough definition, please raise your hand if you think
yeah,
that
I'm eating better. I'm losing
you have a
weight.
substantial
So
hardship
diet,
that will
man.
prevent you from
It's
being a
diet.
juror in this case.
I've lost, like 40 pounds or 45 pounds or something.
317. 352. 311.
And I've been eating a lot cleaner.
343.
So, yeah.
360. 354. 326.
Juror number 364.
So far, that's great.
Juror number 348. Juror number 351. Juror number 346. Juror number 333.
Am I walking? I play kickball on the weekends.
Juror number 338. Juror number 334. Juror number 310. Juror number 341.
The quest to get my Monjourno covered by my insurer continues, though. They haven't approved it yet, so that quest still is continuing.
Okay. So in a minute, I'm going to leave the bench and give you an opportunity.
What is
to fill
TRT?
out those
Testosterone
supplemental
replacement therapy.
questionnaires. I ask
Injected
that when you do so
testosterone.
that you don't talk to anybody about your answers to the questions or to share any comments with other jurors or concerns that you may have about being a juror in general or a juror in this case. If you have any questions or concerns, you can talk to me when we come back out. So with that, we will be in recess. Jim?
Court, all right, please.
Did I do HRT with it? No, I did not do HRT. Initially they did, but I decided not to continue with the HRT, so no. I was taking something to suppress estrogen because when you take more testosterone, it increases estrogen as well. So you have to take something to suppress the estrogen. But I'm not taking that anymore either. So at the moment, my hormones are just in balance. It's nice. Back to the fans, baby. Back to the fans. I have a doctor's appointment on Monday, so we're going to see where we are. I actually dropped by my doctor's office yesterday without an appointment to see if I could like follow up on this whole issue of getting the Mounjaro/Zepbound covered by my insurance. Because for whatever reason, this doctor's office is like the worst I've ever been with when it comes to like calling in and getting help from the office. Like the doctor themselves is great, right? And when you're in office, their assistance is fantastic. But whoever they have manning their lines, like, dude, man, like talking to these people is like pulling nails. They don't understand what I'm talking about. I try to speak clearly and they still don't understand what I'm talking about. It is an exercise in constant frustration. So that is one downside. But so anyways, I just dropped by my doctor's office yesterday, you know, just unannounced and said, you know, okay, I'm having these problems. And, you know, first of all, I said, I think I need new labs because for the TRT to be covered by insurance, for testosterone therapy to be covered by insurance, because previously I wasn't getting it covered by insurance. And I'm like, well, this is dumb. Maybe I can get it covered by insurance and I wouldn't have to pay for it anymore. To get TRT covered by insurance, they need 2 sets of labs. Why do they need 2 sets of labs? I don't know. It doesn't really make any sense. Like, why are we testing twice? Like, we're going to test you to see what your testosterone is, and then we're going to test you again. I don't know. So I was like, okay, so my first question was, did you get the results from my last labs? If so, I need new, exciting labs. So they printed off a copy of my labs, then they handed it to me, and I read it, and I'm like, wow, this number's a lot higher than I thought it would be, by a lot. By a lot. It's also not going to be covered by my insurance because it's like 4 times the threshold, right, for TRT. Because the number is way too good, right? So I'm like, I'm not sure I need a second set of labs anymore because they'll never cover it with these labs. This doesn't make any sense. But then they gave me a second set of labs anyway. So I'm not sure whether or not I'm supposed to do that or not now. So I'll talk to my doctor on Monday and see if they still want me to do the second set of labs because I'm not sure it makes any sense. Although in a month, I'll ask him to like, can I do this in like a month? You know, and do the second set because I'd like to know if in a month if the number is still as good as it was because the number confuses me. But yeah, I'll have him do that. And then I also asked him about the Zepbound/Mounjaro prior approval because last time 2 times ago, I was in the doctor's office because I did a unscheduled appointment. But my last scheduled appointment, which was just about a month ago, the person who was there, like the nurse or their PA or whatever, said that they got the insurance company to agree to cover it. And I'm like, really? You got them to agree to this? They're like, yes, we did. I'm like, okay. So I had them send over a copy of the prescription to the pharmacy and not so much, right? And then they sent over a different prescription because they sent over the Zepbound like 3 weeks ago and not so much. And then apparently like yesterday or something, they sent over the Mounjaro. I don't know. And so I guess they're trying to get that coverage and I'm not quite sure where we're at. So we're trying to figure all that out, I guess. The progress continues with trying to get this covered by my insurance. So we'll see. The journey continues. But we'll see how it all goes. Yeah, Ozempic made you sick. I understand completely. It made me sick too. Ozempic is and Wegovy is semaglutide. It's a different drug. Mounjaro and Zepbound is triseptide, right? It's also a different drug. And this comes with the wonderful nature of trying to find the right drug for you, right? So yes, Ozempic, which is semaglutide made me very nauseous. Triseptide basically has not made me nauseous. So I've had a much better experience by far with the Mounjaro than I did with the Wegovy Ozempic. So yes, the triseptide so far has been as close to a perfect drug as one could hope for. It's basically had no side effects and it has worked basically miraculously. So it's as close to a perfect drug for me as, I've experienced. So that's exciting. Have I thought about keto? I have thought about keto. I've tried keto. I have a real hard time sticking to it. So yeah, I've tried, guys, I'm a fat. Okay. I'm a fat. Over the course of me being a fat, I have tried, as one would anticipate, many different kinds of diets, many kind of different programs. I've tried many and various different things. So before you ask, have you tried X? The answer is probably yes. Okay. I'm just saying. Okay. It's probably yes. All right. So I can say that so far for me, Monjourno has been the thing that has worked and worked most persistently. So I'm very excited about that. And that's nice. So far it's working, and that's hype. All right. So that is, I think, the end of the court hearing. There will be no further hearing. So again, we won't probably tune in again until the start of the trial. If there is, in fact, a hearing relating to any of these pending issues relating to exclusion of witnesses or something, if there's anything like that, we probably won't catch it live. We'll just probably, watch it at a later time and cover it there. All those good things. Watch out for liquids. I had an issue drinking my calories. I have no problem with that. I don't drink calories. I don't drink calories. I drink Crystal Light all the time. Or, sometimes I drink liquid IV so that I get some electrolytes in there. But yeah, I don't drink calories. I don't want to eat or drink anything. It's great. My appetite is just basically gone. I don't want to eat at all, which is nice. I just don't want to eat. It's great. And not eating is nice too. Plus I'm saving money by not eating because I'm not, constantly ordering Uber Eats. So I haven't done the math. But I might actually be better off economically, even at $650 a month, which is a lot for the drug. Like $650 a month is a lot, but I haven't done the math. But it wouldn't surprise me. It wouldn't surprise me if I'm actually saving money versus my food budget. Because I would, when you're ordering out and you're ordering all the time, man, that adds up. So I might actually be coming out ahead, which is really disturbing, but it's strongly possible. So, yeah. Have I tried Red Bull and met RX diet? No, I haven't tried that one, and that doesn't necessarily sound like the best diet plan. So I haven't tried the Red Bull plan. No. All right. Well, that's all exciting. Let me share with you some other stuff that I'm looking at. So yes, the Beefish watch company is really a thing. That wasn't an April Fool's joke. I really am assembling watches, and so I'm still waiting for my first order. It's probably going to take a little while because a lot of it's coming from China. So we're still waiting for the first order, but I'm already scoping out stuff for a second order. So I'm already looking at things and sort of options. So I'll share with you some of the things that I'm looking at for future watch builds, because some of you guys might like some of these things. And so, then you might want to buy one of my watches, and that will be exciting. Are tariffs going to hit the watches? I would anticipate, Beaky. So that could also be a problem, but one problem at a time. All right, I'm going to ask you guys to stop asking me, have I tried X? I just don't want you to even ask me the question anymore. Please stop asking. I don't want to answer the question anymore. Lol. All right. So I'll give you some stuff that I'm looking at. Can I zoom in on this? Yes, I can. Ooh, exciting. All right. So here's some things that I have sort of in my tentative cart for things I'm looking at. All right. I have this 44 millimeter stainless steel case for a mechanical small seconds. So I'll show you the dial for this, or one of my dials for this, to show you what it is. All right, so here is this, what the dial would look like. Or like, here's the idea of the dial, right? So it might not necessarily be this, because I don't really like the half Roman markers, half, Arabic markers. I don't really like that look. But what I do really like is the second hand is at the 6 o'clock position. So that's called a small seconds. And it doesn't necessarily have to be at 6. Some people put it other words, but I kind of like it at the 6 o'clock position. So I was like, okay, I want to make a watch that does a small seconds. And so that's sort of why I'm looking at that, because I just really think that's a very, very cool look. So not necessarily this dial, but that would be the position of the thing. Okay, and so that dial would go into, hold on, this case, right? And you can do either silver or black, and I probably do black. So it would go into this case, and we could put like a strap or a leather band on it or something, and I think that would be cool. That'd be neat. So that's sort of what I'm looking at in that direction. Okay, and then the movement itself for that watch would be this one. So this is the movement for that watch. And this is a 6498 manual wind. So the only thing I don't like about this watch is you have to wind it every day. Or, well, not necessarily every day, but you have to wind it like, every 3 days or something by hand. So it's not an automatic, and it's not quartz. So you actually have to wind it. So that's the only thing I don't like about it. But, if you're willing to get past that, you just pop out the crown and, do it a couple times in the morning with your coffee or something. If you're willing to get past that, then I think that the look is very, very cool. So I'm gonna make that, I'm pretty sure. Yeah, you like the fact you have to wind it? See, some people like it, some people don't. Okay, and then I've got just some other dials I'm looking at. So these would be like for, an NH35 movement, but I got, like this kind of green luster one. I got this one that's all sparkly. Something like this, or something like this, just sparkly and glittery. I thought that was pretty cool. No marks on the dial itself, but that problem can be solved. I can put like a chapter ring on it or something instead to mark the, because the dial itself doesn't have any markers. So either I could just not have markers, which would make it harder to read, or I could just do markers in a chapter ring that I could put on the thing, and that would solve the problem. So there's other ways to solve this problem. But I did like that glittery kind of dial. I thought that was pretty badass. This green one, this is really cool. Again, just like shiny and pretty and colory and nice and interesting and stuff. There's this one. This is cool. We got this sunburst kind of dial. That's pretty badass. This one technically has markers. They're very hard to see, but technically has markers. Well, actually, you don't strictly need the Roman numeral markers. The fact, the Roman numeral markers you could just ignore, really, to be honest. If you can't read it without telling you the number, then you should be able to read that. So but that, I like that with that look. I think that's really, really wicked cool. That sunburst kind of thing, that's pretty sweet. Here's one that I thought that was pretty interesting. This mosaic kind of pattern, this pearl dial mosaic tapestry kind of dial thing. That's pretty cool. That's pretty nice. So I'm definitely feeling that. All right, and then what else we got? Okay, we got this one, this kind of stone-ish style. That's pretty neat. So just a stone kind of look. That's fun. This one. This is nice. I like the texture on this one a lot. This texture is pretty cool. Really nice, easy to see markers. Nice little textured dial. Alternating pattern. That's pretty cool. I like that one a lot. That's really neat. That's nice. Then I have this one that I'm looking at as well. I'm not sure what we're calling this. I guess we'll call it sunrise. We'll call this a sunrise dial with the purple and yellows. That's nice. That will look pretty sweet. Oh, and then I thought I'd make basically a alpinist kind of homage. So we got this dial, which for those of you who are not familiar with this dial, this is the dial without the Seiko marker, but this is the dial for the Alpinist. The Alpinist is a very well-loved Seiko watch. It's about $750, and it's really loved. Now, the one thing the Alpinist, however, has a rotating chapter ring, so it actually has two. It has two crowns. It has a crown at 3 and crown at 4, so that you can rotate the chapter ring. And the chapter ring has the markers for navigation. But I don't really like that. I don't really like the 2 crowns. I don't really like the rotating chapter ring. So that's really not for me. So what I can do instead is how about we just don't have a rotating chapter ring? You know, it'll just be permanently like, you know, north is at 12 o'clock, you know, but it won't have a rotating chapter ring. And so I thought that would be pretty cool. So I'm basically going to make an Alpinist without the rotating chapter ring. And basically is what I'm going to do. And then, of course, for the hands for that watch, you know, you would obviously pick these gold ones here because that would be the right look for that watch. So those would be the right hands for that to look at the Alpinist. And then in terms of the case for it, I have this one tentatively as this movement, although probably actually this, so that you can actually get like, or maybe like this. Yeah, I'll do this. So you get the Cyclops so you can read the date, but no rotating bezel, right? So this one would not have a rotating bezel. This one would just have this clean steel look. And so I'd put the dial inside that with the hands and the Cyclops 40 millimeter. And I think that would be really good. And that would be like a really, really nice, that would be a really nice go anywhere, do anything watch, right? It would, because that Alpinist look is a very sort of classic look. So it would be something that you can easily wear kind of while doing anything. You know, it would dress up and dress down very nicely. So I'm going to sort of make that, and I'm pretty excited about that pattern. And that is basically what I have at the moment and sort of the things that I've been looking at in terms of this hobby. And then, of course, you need to actually buy the movements themselves. So I need to then buy like a whole bunch of NH35 movements so that, you know, you can, and some NH34 movements, because some of them are no date. So for the no date ones like this one, I mean, hypothetically, you could get the NH35, it would work. It would just be weird because, you know, there's no hole for the date. So you could just use an NH35, but then it would basically have a ghost position for the date, although technically it wouldn't be a ghost position for the date. The date's still there. It's just that You won't know. You wouldn't notice. But yeah, so probably NH34, so it doesn't look as stupid. So and also doesn't have the doesn't have the ghost position for the date. So I get it, get the movement without the date on it. So those are the things that I'm looking at right now. And I'm pretty excited about all those things. So, whenever the first order comes, basically my working intention right now here is whenever the first order comes, I'm going to assemble that watch. I'll do it on stream, obviously. I'll assemble it with you and me together. And then, I'll sell the watch. And then, with the proceeds of that, then I'll buy some more stuff and, so forth and so on. And, so that's all exciting. And then, probably for, I would imagine for at least like 6 months or a year, if this hobby sticks on, I'll just be kind of doing that. I'll be taking pre-assembled components. I'm going to do some quartz movements. I really want to do the mecha quartz movements from Seiko because I just think they're really cool. The quartz movements with smooth second hands. So I think it's that VH34 movement is what it's called. It's a 3-handed dial, but the second hand ticks 4 times a second. So you get that smoothish, you get a smooth kind of sweep of the second hand, even though it's not mechanical. So I'd really like to make some quartz, particularly using that movement, because I really like it a lot, because you get all the accuracy of quartz with the smooth second hand. And I just think that that's absolutely badass. And then also at some point, I'd also like to make some smaller watches for women as well, because these watches are all going to be like, 40 millimeter or even bigger. And so I'd like to also try to make some smaller watches for women, 36 or 34 millimeter as well, and go from there. And that sounds like fun times have by all. So that is sort of what I'm looking at doing. And then, if the hobby goes really, really well, then, at some point in the future, we could do even more custom stuff. So we could, if it goes really well, either, at some point I'll get equipment and, make my own stuff, or probably more likely I will find a company to make stuff for me. So I'll start, actually making custom dials, and I'll make custom stuff. And, there's companies that do that, obviously. And so I can find a company that will, transform my artistic vision, and it will be more customized, probably using some sort of edit movement or something. And that will be fun. So all those good things. So we'll see how it goes. And if there's anything anyone in particular wants, then obviously I could try to make something that, would be good. We'll get you something that you'll like, I'm sure. And of course, they will all be labeled B-Fish because I got the B-Fish stickers, which hopefully I will be able to put on straight. We'll see how that goes. That's going to be probably the most challenging part, will be putting on the sticker completely straight. That will be the biggest challenge. I don't know how I'm going to do that practically, especially with my hands and them shaking. It's going to be really challenging to put on the hand straight or the sticker straight. So I'm not sure how I'm going to be able to pull that off, but that'll be fun. Use a ruler. Yeah, we'll see. We'll see how it goes. We'll see how it goes. It's going to be challenging. Of course, if the company goes really well, at some point, maybe I'll do like laser engraving. Maybe I'll get myself a Temu laser engraver and I'll just laser engrave the dial, and that will be cool. But, those are goals for another future. All right, cool. Yeah. Yeah. Ear handshake. Yeah. Yeah. All those good things. On talking watch. No talking. No talking watches. Temu laser engraves for the win. Yeah, exactly. So we'll see if we can get a laser engraver at some point, but obviously that's going to be expensive. So, you know, the capital outlay, you know, we won't do that until we can justify the cost. All right, let's see what else is happening in law today that we can talk about before I let you guys go. Make an Amazon wish list. Well, I'll probably sell each of the watches on eBay is probably what I'm going to do, because that sounds like the most logical thing to do. So I already have an eBay account, so I'll you know, change the name of the eBay account to the B-Fish watches or something, and then I'll just put them up on eBay, and then, you know, any member of the channel plus any member of the public can bid on them, and that sounds plausible. Should make an Amazon wish list so you can help me buy stuff. Oh, that's a reasonable point. What is this? Okay, so we got a couple Supreme Court case decisions today, apparently. Okay, so we got 2 Supreme Court decisions, it looks like, that came down today. That's exciting. Let's do some Supreme Court opinions today. Yeah, I'll send watches to LawTube friends. I'll absolutely be doing that as well. 100%. I will absolutely be sending for free my watches to my LawTube friends as well down the line. So 100%. And of course, we also will be auctioning off some of those watches, assuming the hobby sticks out. We'll also be auctioning off the watches to charity in November. So those are also part of the plan. So yeah, Ian is getting a free watch, I assure you, at some point down the line. Ian sent me coasters and Rob sent me a pen. So they each get something made by me, you know, once I have something to give them. And then I'll try to figure out, like, you know, then I'll try to make something I think that makes sense for them, right? That'll be the ultimate thing. Like, try to find, you know, the thing that, like, I'll buy a gift that, like, that at least to me reminds me of them, right? So it's like, I made this watch because this watch reminds me of you, and hopefully they also like it. We'll see. Watch that looks like the bottom of a shell casing. Yeah, maybe. We'll see. We'll see. One step at a time, guys. One step at a time. We'll see. We will see. All right. We turn our attention to the U.S. Supreme Court in the case of FDA versus Wages and White Line Investments, doing business as Triton Distribution. Exciting. Let's see what's going on with the FDA. This case concerned where the FDA lawfully denied respondents authorization to market certain electronic nicotine delivery systems known as electronic cigarettes, e-cigarettes, or vapes. Okay, so we've got a company that like to make some vapes, and the FDA says, how about no? Okay, these products have rapidly gained popularity during the past 20 years, offering existing smokers a potentially safer alternative to traditional combustible cigarettes. Debatable, but you know. But e-cigarettes carry their own health risks, and a panoply of available flavors, which include not only traditional cigarette flavors like tobacco and menthol, but also fruit, candy, and dessert flavors, appeals to non-smokers, particularly young Americans. It could be a problem, to be sure. The FDA has long held the responsibility to determine whether manufacturers may market new drugs, but it was the passage of the Family Smoking Prevention and Tobacco Control Act that first gave the FDA broad jurisdiction to regulate tobacco. So the FDA traditionally did not have authority to regulate tobacco. It was not under their jurisdiction, but then the Congress passed the law and gave them more jurisdiction. Although the act barred the FDA from banning all regulated tobacco products outright, it prohibited a manufacturer from marketing any new tobacco product without FDA authorization. So the FDA, you can't ban it, but you might be able to regulate it, and you can regulate new products. All right, makes sense. The relevant law requires the FDA to deny such an application unless the applicant shows the product would be appropriate for protection of the public health. So it's on the person producing the product to show it's safe, basically, within the meaning of whatever that means for tobacco. To determine this, the FDA must consider, among other things, the risks and benefits to the population as a whole, and take into account the likelihood that users of existing tobacco products will stop using those products and that non-users will start using them. Seems reasonable, right? Those seem like reasonable factors for the FDA to consider. And also, even more to the point, Congress said to do it. So it isn't even the FDA saying, here's some factors we want. It's Congress saying, do this. So it's like, okay. In 2016, in response to surging youth demand for flavored products, the FDA deemed e-cigarettes to be tobacco products. Okay. Given that most e-cigarette products were not marketed in the United States before February 15th, 2007, the vast majority of these products qualify as a new tobacco product. Well, new relative to when the law was passed, sure. Most manufacturers of e-cigarettes products would thus need to comply with the law's pre-market authorization regime to sell products. This made the continued sale of most e-cigarette products illegal, absent authorization. So to give these manufacturers adequate time to submit pre-market tobacco products, the FDA delayed enforcement for 2 to 3 years. This permitted e-cigarette products to remain on the market while manufacturers filed their application. A federal district court ultimately imposed a deadline of 2020 for the application. All right, that sort of makes sense. So we got some products that, the statute says if they're new products, you need to regulate them. But the FDA is like, look, a lot of these products are already on the market. So we're going to give you a delay so that we just don't, just come down on a hammer. We're going to give you some time to apply first. The FDA is being very nice. But of course, the niceness isn't enough, I'm sure. In the lead up to the application deadline, the FDA issued numerous forms of guidance concerning pre-market tobacco product applications that orbited around 4 central themes: the type of scientific evidence that would be required, the importance of cross-product comparison and investigation, the FDA enforcement priorities with respect to device type, and manufacturer marketing plans, which were described as specific restrictions on sale and distribution meant to deter new smokers from taking up e-cigarette products, which, to be fair, the FDA, that seemed to be one of the factors Congress explicitly asked them to take consideration of. In 2019, the FDA posed a new rule related to submission of pre-market tobacco product applications, and proposed rule distilled the top 4 discussed in the guidance. Respondents submitted applications seeking approval to market and sell flavored e-liquids for open system e-cigarettes. The FDA denied respondent application, concluding they did not provide sufficient scientific evidence to demonstrate that the marketing of their products would be appropriate for the protection of public health. Specifically, the FDA held respondent had not provided evidence from a randomized controlled trial, longitudinal cohort study, or other robust and reliable evidence that the dessert, candy, and fruit-flavored products have benefit over tobacco-flavored products. Despite previously describing marketing plans as critical, the FDA decided for the sake of efficiency not to evaluate their marketing plans. Well, they're like, we can decide this on other grounds, basically. It's like, so we don't need to consider your marketing plan because the product itself is defective. So it's like, yes, the marketing plan is critical, but they're critical along with other things. So it's like we were able to solve this easier, so we didn't look at the thing. That kind of makes sense to me. All right, these lengthy documents, which canvass the scientific literature on youth e-cigarettes use, reflect FDA's evolving understanding of how flavor, regardless of e-cigarette device type, drives youth smoking initiation and nicotine addiction. Okay, fair enough. Respondent petitioned for judicial review from the FDA denial orders under the Administrative Procedures Act. The Fifth Circuit sitting en banc granted respondent petition for review and remanded to the FDA. The en banc majority held the FDA had acted arbitrarily and capriciously by applying application standards differently from those articulated in its pre-decisional guidance document regarding scientific evidence, cross-flavor, and device type. Yeah, I'm not feeling arbitrary and capricious. It feels more like, to me, the FDA said, I can solve this problem easier. I don't need to consider your marketing plan because you failed on another element, and so I don't need to go further. That sounds more like what it's like to me. The court expressed particular concern about FDA's failure to review marketing plans it previously deemed critical. It also rejected the FDA argument that any error was harmless. All right, so what is the law? Held. As a preliminary matter, the court declines to reach and thus expresses no view on respondent that argument that the FDA erred in evaluating respondent's application under standards developed in adjudication rather than standards promulgated in notice and comment. This complicated question sweeps beyond the question presented and lacks briefing. So as to that element, it's not what we thought we were going to do, and so we're not going to consider it right now. So no. The Fifth Circuit conclusion that the FDA acted arbitrarily and capriciously in its adjudication manufacturer pre-market tobacco products application is vacated because the FDA denial orders were sufficiently consistent with pre-decisional guidance as to scientific evidence, comparative efficiency, and device type, and thus did not run afoul of the change in position doctrine. I feel that. Yeah, that doesn't feel arbitrary and capricious to me. Yeah, I'm not feeling it. Arbitrary and capricious is pretty hard. You know, they're not acting like randomly and wantonly. They're not just, throwing darts at a board. No. The court analyzes the Fifth Circuit conclusion that the FDA acted arbitrarily and capriciously under the change in position doctrine, which provides that agencies are free to change their existing policies so long as they provide a reasoned explanation for the change, display awareness of their changing position, and consider reliance interests. The doctrine asks two questions. First, where the agency changed an existing policy, and second, where the agency displayed awareness of the change and offered good reasons for the new policy. The FDA denial orders were sufficiently consistent with its pre-decisional guidance regarding scientific evidence. I mean, seems like it to me. The law states that either well-controlled investigations or other valid scientific evidence, if found sufficient, may support a finding that new tobacco products is appropriate for protection of public health. The relevant law thus left the FDA broad discretion, and again, no Chevron, but then again, we don't necessarily need Chevron because the statute also often gives the regulatory agency discretion. That's not the problem, right? The problem isn't how much latitude did they give the FDA, right? The problem is, what is the nature of that latitude? Right. So under Chevron in the dark ages, it was up to the agency basically to decide what the statute meant. And it's like, no, that's not right. The courts decide what the statute means. But just because the court decides what the statute means doesn't mean that Congress didn't give them a lot of latitude. Congress might have given them a lot of latitude. Congress can be as specific or as general as it wants, basically all things considered. And so, in this domain, they gave the FDA a fair amount of latitude. So it's like, okay, that's just the right answer. Okay, Congress passed the law. We're just respecting the law they passed. Cool, no problem. I'm fine with this. The FDA thus left FDA broad discretion to decide what sort of scientific applicant the applicant was required to submit. Across its various guidance documents, the FDA's main point was manufacturers who failed to submit evidence based on well-controlled investigations would need to provide rigorous scientific evidence the sale of their particular product would be appropriate for protection of the public health, which, again, the statute itself placed the burden on the person wanting to market the product. It's like, you're the one who has to prove this. You're the one who has to prove it, not the FDA. But that's what Congress wanted. The applicants did not submit randomized control trials or longitudinal cohort studies, so the fate of their application turned on whether they submitted other evidence that met the FDA standard of the product. And by the way, of course, as always, when they say other evidence, right? We know how to interpret that, right? When they say other evidence, what do they mean by other evidence? What do they mean by it? Well, what they mean is when they say and other stuff, when Congress says and other stuff, what they mean is other stuff like the stuff we gave you, right? It doesn't mean all other stuff. It means other stuff like the list, okay? So Congress said, okay, we'd like you to consider randomized controlled trials. We'd like you to consider longitudinal cohort studies or other evidence. So what do they mean by other evidence? They mean other evidence that would be like randomized controlled trials or longitudinal cohort studies. So broadly speaking, they're looking for some sort of scientific peer-reviewed evidence or other sort of studies that would meet the standards in a scientific fashion that would be like that. That's what they mean. They don't mean all other evidence. They mean other evidence like that evidence. That's what they mean. Etiam generis. We interpret the term in company it keeps. The FDA rejected respondent's application because the test was not met. As evidence of change in position, respondents point to the FDA's July 9, 2021 internal memorandum, which stated the failure to submit evidence from a randomized control trial or longitudinal cohort study would likely constitute a fatal flaw that would likely result in it. Yeah, I mean, probably, because there's not a lot of other things that are probably like those things. So it probably would be problematic. But the FDA issued a superseding memorandum, which recognized that other evidence may demonstrate a product for the protection of public health, and FDA representatives did not rely on the internal memorandum. So yeah, I have no problem with this. This sounds all fine to me. The FDA comparative efficacy requirement was not inconsistent with its pre-decisional guidance. The relevant law expressly contemplates comparison of different tobacco products, and the FDA guidance elaborate on the type of comparisons that would be helpful. So again, Congress said one of the ways that you should do this is by comparing the product they want to other products on the market, right? Congress wanted you to do that. And so it's like, okay, cool. Here's how we're going to try to go about doing that. Here's what we think would be helpful to us in making the comparison. Seems pretty reasonable to me. All seems okay to me. The FDA's 2019 guidance recommended that manufacturers compare the health risk of products to both products within the same category and subcategory, as well as products in different categories as appropriate. Makes sense to me. And a 2020 enforcement guidance telegraphed the FDA view that dessert, candy, and fruit flavored products were more likely than tobacco and menthol products to appeal to the young. So that seems like a pretty reasonable conclusion. And one of the things the FDA is concerned about is the youth taking up these things. Seems pretty reasonable in light of the law. Thus, when the FDA denied respondent's application for failing to demonstrate the benefit of the flavored products over tobacco flavored, it was following a natural consequence of its pre-decision guidance. This all sounds okay to me. The FDA's treatment of device type did not violate a change in position doctrine. The FDA's 2020 guidance did not establish a safe harbor for non-cartridge based products. Although the 2020 guidance emphasized the FDA would prioritize enforcement against cartridge-based products, it stated that the FDA would also prioritize enforcement against manufacturers whose product marketing is likely to be promote use by minors. The latter category seemingly covers respondent products. Even if FDA changed its position in this respect, it offered good reason, namely evidence showing that youth demand has moved from flavored cartridge-based products to flavored disposable products. So it's like, even if we changed our position, we did it in response to the market because this is what youth people seem to be smoking more. And so that seems like a pretty reasonable change. And also, this also relates to enforcement priorities and what they're choosing to focus on, which seems within executive discretion. So all those things. From the evidence, the FDA drew a reasonable inference the youth were most strongly drawn by flavor rather than device type. Sure, the First Circuit relied on an overly broad reading of Calcutt versus FDIC to reject the FDIC's claim of harmless error regarding the agency change on the position of marketing plans. The FDA does not contest that despite assuring manufacturers that marketing plans would be critical, the FDA did not ultimately consider respondents' marketing plan. The FDA argued below that any error in this respect was harmless because it issued denial orders to other manufacturers after reviewing marketing plans that were materially indistinguishable from respondents. Also, it doesn't really turn on the marketing plan. That wasn't the problem. So yeah, again, it just feels like we solved the problem at the easiest way to solve the problem. We solved the problem with the flavored cartridge. You didn't consider our marketing plan. Yeah, because basically no marketing plan would have mattered. It was irrelevant. It was irrelevant. No marketing plan is going to solve this problem. So we didn't consider the irrelevant. You're correct. Congratulations. The Fifth Circuit rejected FDA's harmless error argument, relying on this court's decision in Calcutt for the proposition that AP errors are only harmless where the agency would be required to take the same action no matter what. In all other cases, the agency cannot avoid demand. The court agrees with the FDA that the Fifth Circuit read Calcutt too broadly. That said, the proper standard presents a difficult problem, requiring reconciliation of the so-called remand rule developed in SEC versus Chenery. So basically, we think you overread our case, but also we understand why you overread our case. So we're going to fix it. You know, we didn't really mean exactly that. We spoke poorly. So we're going to fix it. Okay, cool. That said, the proper standard requires a difficult problem requiring reconciliation of so-called remand rule developed in SEC versus Chenery with APA instructions that reviewing courts must take due account of the rule of prejudicial error that ordinarily applies in civil cases. The most natural interpretation of the APA's language is reviewing courts should adopt the rule of prejudicial error applicable in ordinary civil litigation, also known as the harmless error rule, to the administrative law context, which of course includes the remand rule. In Calcutt, after reciting the remand rule in strong terms, the court acknowledged that remand may be unwarranted where the agency was required to take a particular action because there's no point in remanding. We had to do it, right? So there's no point in remanding if we have to do it no matter what. So what's the point? Although the Fifth Circuit interpreted Calcutt's discussion to mean there's only one exception to the remand rule, it's long been accepted that remand may not be necessary where an agency's decision is supported by a plethora of factual findings, only one of which is unsound, because remand would be pointless. So basically, we're just going to standard harmless error analysis. You know, harmless error analysis, because there's no point. Okay, fine. The existence of this exception is sufficient to show the Fifth Circuit reading of Calcutt went too far. That said, the FDA's reading of Sanders may also be excessive. The FDA has not asked this court to decide the harmless error question at this juncture, and the court vacates or remands so the Fifth Circuit can decide the question afresh without relying on the overexpensive reading of Calcutt, which means we're almost certainly going to be back. Justice Alito files an opinion for a 9-0 unanimous Supreme Court. So that is that. So Congress passed a law, said regulate the tobacco products. No one seems to have a problem with the fact that these are in fact tobacco products, potentially despite the lack of tobacco, but no one cares. And we're just regulating it based on the fact that, you know, you didn't do the studies and you need to do the studies. And yes, the FDA didn't consider your marketing plan, but they didn't have to because they rejected you on the product. And so that's dumb. And the Fifth Circuit can also, in the first instance, decide whether this is harmless error or not. And the Fifth Circuit's going to say it's not. And then we're going to go back to the Supreme Court to say it was. But, you know, that's fine. So we're going to bounce up and down the courts for a while. But that brings us to the end of consideration of that particular case. All right. And then we have another case. Exciting. Medical marijuana versus Horn. Let's read about medical marijuana. We turn our attention to the case of Medical Marijuana Incorporated. First of all, calling your business Medical Marijuana Incorporated is just pretty badass. I have to say that that's just, I respect that choice. We literally called our business Medical Marijuana Incorporated. I respect that. Medical Marijuana Incorporated versus Horn. Let's read this decision. Seeking relief from his accident-related chronic pain, Douglas Horn purchased and began taking Dixie X. Yeah, that screams reliability. Dixie X, oof. A purported THC-free, non-psychoactive CBD tincture produced by Medical Marijuana Incorporated. A few weeks later, however, Horn's employer selected him for a random drug screening, and Horn tested positive for THC. Lol. After he refused to participate in a substance abuse program, his employer fired him. Horn then sued Medical Marijuana under RICO. Wow, we're hardcore, man. Wow, we're not just suing you for anything. We want to sue you under RICO? A civil RICO? Wow, we're not playing around. Holy shit. Horn then sued Medical Marijuana under RICO, which creates a cause of action for any person injured in his business or property by reason of a criminal RICO investigation. Violation. Holy shit. The district court granted summary judgment to Medical Marijuana. Wow. Wow, that's tough. The district court actually ruled in your favor on a summary judgment on a civil RICO. Wow. Wow, that's hard. That's really tough, man. Damn. You know, Pope Hat says it's never RICO, and he's not wrong. So we have the district court granting summary judgment on a civil RICO. Holy shit. Woof. Horn lost employment derived from a personal injury ingesting the THC, the court reasoned. And in the court's view, Section 1964 forecloses recovery not only for, they decided for Medical Marijuana. Oh, okay, I thought they decided for Horn. Okay, never mind, sorry, damn, I got that backwards. No, they decided for Medical Marijuana on summary judgment. Okay, that makes way more sense. No, I got the parties confused in my head for a second. Sorry, I retract my previous incredulity. They decided against the guy suing summarily. Ah, no, that makes way more sense. I got the parties confused in my mind. I apologize for the error. Okay, anyways. And in the court's view, Section 1964 forecloses recovery not only for personal injury, but also for business or property harms that result from such injury. The Second Circuit reversed, concluding that Horn had been injured in his business when he lost his job. In doing so, the Second Circuit rejected the antecedent personal injury bar, a rule adopted by several circuits that precludes injury for business or property losses that derive from personal injury. Okay, so is this only in losses relating to business or also personal injury if it affects your business? That's the question. Very sort of narrow question. All right. Under civil RICO, a plaintiff may seek treble damages, that's ×3, for business or property loss, even if it resulted from personal injury. Wow, the Supreme Court is giving Horn a chance. Wow, man. The Supreme Court is allowing the civil RICO to proceed. Exciting. Exciting, man. Damn. The sole question before the court is where a civil RICO categorically bars recovery for business or property losses that derive from a personal injury. The court does not address issues implicated by this case, but outside the scope of the question presented. Yeah, we're just answering something very narrow, guys. Please don't overread us. That is, whether Horn suffered a personal injury when he consumed the THC, whether the term business encompasses all aspects of employment, and what injury in his property means for the purposes of this law. So there are still many, many exciting questions that we are definitely not answering right now. Just to be very clear. Section 1964 provides any person injured in his business or property by reason of violation of RICO may sue. The ordinary meaning of injure is to cause harm or damage to or to hurt. So the meaning of 1964 is straightforward. A plaintiff has been injured in his business or property if his business or property has been harmed or damaged. Even so, 1964 does not allow for recovery of all harms. By explicitly permitting recovery to harms to business and property, 1964 implicitly excludes recovery for harms to one person. But business or property requirement operates with respect to the kinds of harm for which the plaintiff can recover, not the cause of the harm. For example, a gas station owner being up in a robbery cannot recover for pain and suffering. But if the injuries from the robbery force him to shut his doors, he can recover from the loss of the business. Again, by the way, when they say that, they don't mean in general. They mean within the confines of this particular statute. Okay? So when they say the gas station owner being up can't sue for his personal injury, they mean under RICO. Okay, he can't sue for personal injury, but he can sue, for loss to his business if it was derived from the personal injury. It's not the thing, it's the cause of the thing, right? So the personal injury is both a thing unto itself and also can be the cause of another thing. So even though you don't have liability under RICO for the thing, you have liability because it caused another thing, and proximate cause and so forth and so on, and all that stuff. So, fair enough. Fair enough. Medical marijuana argues that while the injury ordinarily means harm, it can also mean an invasion of a legal right. Seizing on the latter definition, medical marijuana asserts that injury in his business or property means suffered in invasion of business or property rights, such as a business or property tort, which is not an unreasonable way to read it, medical marijuana, to be fair. That is not an unreasonable idea. And medical marijuana contends that the invasion of personal injury right never gives rise to RICO. So if a personal injury tort causes a business or property harm, the plaintiff cannot recast the harm as a basis for RICO, which is a very reasonable idea by medical marijuana, because basically they're trying to argue that you're relabeling it. And right, we don't do law by magic words, right? So it's like, okay, it's not a personal harm, it's a business harm, right? So they're like, medical marijuana is all over here, like they're trying to put a different label on the thing, and it's not working. Okay, that's their argument. Not a wholly unreasonable argument. Not a wholly unreasonable argument, but didn't work here. Medical marijuana, in fact, tries to make a term of art argument without the term of art. True, injury can mean invasion of a legal right, but even legal dictionaries confirm injury often means harm or damage. In any event, when a word carries both ordinary and specialized meaning, context determines the choice. So, did Congress mean this, as a term of art, or did they mean it generically? And one of the ways to figure that out is by reading the statute as a whole. That makes sense. Here, context favors ordinary meaning. The statute uses injured, not injury, and dictionary medical marijuana defines injury only according to its ordinary meaning. And medical marijuana's argument based on the presence of the word damages is untenable. The phrase threefold the damages he sustains refers to monetary redress. A plaintiff may recover triple the amount that makes him whole. So triple damages under RICO. So, 3 times my loss. So cool. Medical marijuana ignores the many cases in which the court has used injury, harm, and other terms connoting loss interchangeably. Compensatable injury is necessarily the harm caused by predicate acts sufficiently related to constitute a pattern. Medical marijuana's tort-centric definition of injured also stands in significant tension with its court's holding in Yegasarian versus Smagan. In Yegasarian, the court addressed the circumstances in which injuries to property qualify as domestic and thus provide a basis for recovery under 1964. Yegasarian urged the court to rely on common law principles governing the situs of injury and property injuries, where it occurred. After questioning whether such common law principles were even germane to 1964, the court rejected their application and instead adopted a contextual inquiry. In other words, the court rejected an appeal to rely on common law, deeming the approach inconsistent with the threat of 1964. So, of course, for example, when Congress passes a statute, it might be the common law, but of course it might not necessarily be the common law because Congress can change it by statute. And so here, the Supreme Court thinks it changed it by statute and didn't mean the common law meaning. Cool, fair enough, cool. While medical marijuana insists this court's antitrust precedent settles the question, that's a very weird thing to say, right? Why would antitrust law necessarily read on to RICO? It seems, I can see how they might be related, but why would the one necessarily control the other seems a bit odd to me. Did this guy have a medical card? I don't know, and also it doesn't matter for the purpose of this analysis, right? First of all, he wasn't trying to buy THC. Second of all, even if he did have a medical card, his employer could still fire him because it's at-will employment. So even if he had a medical card, well, To be fair, you might get into ADA territory, but not necessarily. So, yes, absent the Americans with Disability Act, which I'm not sure would necessarily apply, although it might be an interesting case. But absent the Americans with Disability Act, a private employer could fire a person for using marijuana even if they have a card. Unless, of course, state law provides some sort of specific protection on this point, but I'm not aware that any state does. So, yeah, that's not the issue. Medical marijuana offers a little guidance on how courts should assess whether a plaintiff has suffered a qualifying legal injury. In fact, the conclusion medical marijuana draws from its own hypothetical rely on pure ipse dixit. Lol. You're just making shit up. It admits, for example, that draining a bank account using a computer password obtained via violence injures the account holder property. It concedes that 1964 allows for recovery for ransom payment despite the antecedent kidnapping, and insists that human trafficking victims can sue for business or property harm despite it resulting from captivity. But if the antecedent personal injury bar exists, it's unclear why any of these plaintiffs can recover. So basically, your own hypotheticals don't work. You're like, but these people can recover, but why? Why can they recover? If the personal injury bar is a bar, they wouldn't be able to recover, but even you according to your own thing. And then it's like ipse dixit because we said so. It's like, no. Could they fire you if you had a prescription for anything else like taking insulin? Yes. Yeah. Assuming, again, the Americans with Disability Act does not apply, then yes, they could fire you for taking any prescription. Assuming that they would know about it, which, is a whole nother set of problems. But yeah, but let's make it even broader than that, right? In the absence of a law that protects you, your employer can fire you for any reason. So, that's the broader answer, right? In at-will employment, your employer can fire you for any reason in the absence of a statute that says they can't. So the reason they can't fire you because of race is not because that's generally good. The reason they can't fire you because of race is because of the 1964 Civil Rights Act. The reason they can't fire you for, just because you're handicapped in and of itself would be like the ADA, right? So yeah, in the absence of a statute, your employer can fire you for any reason, including taking insulin, because you have no protection in the absence of a statute. So yes, that'd be correct. Yeah. In the absence of legal protection, you have no protection. So, yeah. And of course, even the ADA only requires reasonable accommodation. So if the nature of your drug inhibits you in a way, they could fire you for that reason. So suppose you were we'll make it easier, right? We'll make this trivial. Like, let's suppose that you're a forklift. Let's suppose you're a forklift operator. Okay, you're a forklift operator, and you have some condition, and your doctor prescribes you medication that precludes you from operating heavy machinery. Okay, if your employer learns about it, can they not let you be a forklift operator anymore? You bet your ass, right? You bet your ass. It's like, oh, but I'm protected by the ADA. It's like, no, you're not. The ADA only requires us to give reasonable accommodation. And we might have to give you a different job. We might not be able to fire you completely. We might not be able to do that, but we can prevent you from being a forklift operator. And if you don't have qualifications to do anything else, then we could fire you completely. So yeah, absolutely. So yeah, all those things. Yeah. Defining injury by reference to legal rights also raises questions about defining the right at issue. Medical marijuana proposes solutions that courts should consult. The complaint, state law, and general tort principles does not work. Taking those sources in order, the parties' disagreement over whether Horn pled a personal injury exposes the problems when looking at the plaintiff's complaint. Relying on state law would create choice of law questions, and looking to general tort law poses problems of its own. Not only is this general tort law, this is going to be fun. I can tell already. This sounds like legal nightmare fuel here right now. This sounds like we're going to be having problems in court for quite a while. All right. Not only does general tort law not only clearly distinguish between business, personal, and property, but it's also difficult to apply when there's no clear analog or majority rule. So how do you define injured? The Supreme Court isn't quite sure. Is it state law? No. Is it general law? Also no. Okay, so what is it? What is it? Medical marijuana warns the Second Circuit rule will eviscerate RICO's business or property limitations, allowing plaintiffs to transform personal injury claims into RICO for treble damages. But medical marijuana understates the other constraints on civil RICO. Even so, civil RICO has no doubt evolved into something quite different from its original conception of its enactors. And medical marijuana is not the first to express concerns over over-federalization of state law claims. As the court has stated before, if a statute allows undue proliferation of RICO, the correction must lie with Congress. Yeah, district courts hate RICO. Barrett delivers the opinion of the court in which Sotomayor, Kagan, Gorsuch, and Jackson join. Thomas files a dissent. Kavanaugh delivers a dissent in which Roberts and Alito join in a 5-4 opinion, which I'm not completely surprised about because the courts really hate civil RICO. They super hate civil RICO because it's a pain in their ass. Because a lot of people use RICO as I'm just really mad button. And the courts have seen so much garbage RICO, civil RICO, that most of the courts require specific pleading for civil RICO, which isn't normally required. Normally, in civil law, we just require general notice pleading, right? If you want to sue somebody, you just have to provide the basic outline. You have to provide enough facts that, indicates the person did it. Right? You have to tell them what they're being sued for, and you have to provide enough facts so that it's, we understand what we're talking about. But you don't have to go into details. You don't have to list out everything. In specific pleading, you do. In specific pleading, basically, you have to spell out the entire case in the complaint in advance. And you basically have to say everything in somewhat excruciating detail. And one of the reasons the court did that is because they were so tired of seeing bullshit RICO that a lot of them are like, we're going to require specific pleading because we're so tired of bullshit RICO. So I'm not surprised it's 5-4 because the Supreme Court's we just opened up RICO a little bit more. And despite all of our language basically trying to clamp this down, we just opened it up a little bit more. And we just opened up a potential wave of bullshit. So I'm not surprised the Supreme Court's 5-4 on this one, because I think they're thinking about the pragmatic consequences and they're not thrilled. But that's one of the things I'm thinking as I'm reading, sort of getting into their head. But those are both very, very interesting questions. I like both those questions very much. All right, what else do we got today? 274 of you watching. That's nice of you guys. I like that you're here spending time with me. You guys kick ass. Let's see, what else are we doing today? Excuse me. All right, let's check OYA and see if any of these oral arguments are available yet from the recent days, because we might do one of those now. Let's see what we got. All right, is Rivers versus Guerrero up yet? Still no. So no Rivers versus Guerrero, no FULD versus Palestine, still no. So we can't do any of those things yet. All right, is there anything else that we could sort of cover? Let's see if we can find anything in the news the courts of appeal have done recently. Oh, by the way, incidentally, because I wasn't watching chat yesterday when I was doing the stream for the dismissal with prejudice. I wasn't watching the stream because I wanted to remain on focus. But some people were asking like about Trump, and Trump is a different posture, right? Because Trump wasn't president at the time. He wasn't a political official at the time that they were seeking criminal indictment. They weren't jerking him around in the same way. So the factors that led the court to issue the prejudice didn't seem to be present with Trump. Now there are other reasons to oppose the criminal actions against Trump, but I didn't think that was a particularly good argument. So I think people saying, what about Trump? Double standards. I don't think it was a double standard. I just don't think that it's quite in the same domain. But that's me. Let's see what else we got going on. An appeal court said that January 6 defendants are not covered by unrelated crimes. So some of the January 6 stuff might still be percolating. In terms of what does the pardon cover and what does it not cover. Young thug probation revocation, I can't be bothered to care. It's not for me. It's not for me. Young thug is such a nightmare. There's too much going on for me to just pop in, just too many things happening. Do I think there's no reason for you to be sorry. I wasn't trying to be mean to you. I was just like, it's just not for me. So yeah, I didn't mind the suggestion. I was just trying to tell you it wasn't for me. There's no reason to be sorry. You're fine. It was a suggestion made in good faith. You're good. So appeals court. Trump pardon plainly did not cover January 6 unrelated crimes. A federal court has rejected a Justice Department claim that the pardon of crimes related to January 6 riot is so broad it sweeps in convictions for illegal possession of weapons 5 months later. Yeah, that doesn't make any sense. Yeah, I don't know why pardoning people for their activities on January 6 would have anything to do with them illegally possessing weapons 5 months later. That makes no sense, Justice Department. Why would you even say that? That's dumb. In a ruling, the D.C. Court of Appeals split 2-1 in turning down the Kentucky resident Dan Wilson's bid to avoid reporting back to prison to serve the remaining time on his 5-year sentence on charges of possessing an unregistered firearm and being a felon in possession. Wilson was a member of the mob that stormed the Capitol and was charged with multiple crimes relating to January 6. During the FBI's criminal probe of the riot, investigators found an arsenal of illegal firearms at his home. The weapons were not connected to his involvement on January 6. And even if they were connected to the attack, they're a distinct crime, right? It's like even if he had brought the weapons to the Capitol and used them on January 6 in some sense, it's not like your continued possession somehow becomes legal. That's a different crime, right? Maybe you're exempted from possession on January 6 by the pardon, but it's not like you get an ongoing pass. That doesn't make any sense. Yeah, that's dumb. Barring intervention from the Supreme Court or some further action by Trump, the appeal court seems likely to return to prison for the weapons charge. Pallas told Politico he tends to seek appeal to the Supreme Court, which no, and may ask Trump to issue a new pardon. Well, if Trump issues a new pardon, then that's fine. Obviously, Trump can issue a new pardon, and that will solve the problem, but not on the pardon as issued. By again pardoning Willis, he will show the courts he has the upper hand. Well, no, he's not showing the courts he has the upper hand. He's showing the court he has the power to pardon, which no one disputes. But what is the scope of that pardon? He's going to show the courts. I don't think so. I don't think so. The panel's majority conclude the plain terms of Trump mass pardon include only crimes directly connected to the attack, not those discovered by happenstance. Yeah, I mean, we were investigating you for one crime, but we found other crimes. That'd be dumb, right? That'd be completely dumb. No. The pardon's language plainly lies to a related offense, not an offense that's only connected by happenstance. Judge Ray dissented, questioning whether judges have the authority to interpret pardons. Of course they do. How would judges not have the authority to interpret pardons? That doesn't make any sense, Judge Rayo. Of course they have the ability to interpret pardons. It's a legal thing. Who, if not the judges, then who? Who has the ability to interpret them? What? And suggested the court should defer Department of Justice about their scope. No, that doesn't make any sense, right? That doesn't make any sense. It doesn't make sense for a very pragmatic reason. Suppose that President Trump issues a pardon on the last day of his term, right? Suppose President Trump issues a pardon on the last day of his term, and then suddenly a new president comes into power, and the new DOJ says, "Oh, the pardon doesn't mean that. It means blah 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 blah." Right? And Judge Rayo would be over here like, "Oh, it obviously doesn't mean that. The Department of Justice wins." No, that's stupid. That's dumb. Don't be dumb. Don't be dumb. Shortly after Trump signed the clemency, the Bureau of Prisons released him. However, weeks later, Justice Department argued it's an error because the Trump pardon was narrow and should not be read to cover the offenses. About 2 weeks after that, prosecutors reversed course and said they were meant to absolve January 6th of a range of other crimes. That doesn't make any sense. Yeah. So, I mean, this is a lot of stupid. This is a lot of stupid, and no. So I have no problem with any of those things. Appeal court upheld conviction of 2 men in plot to kidnap Michigan Governor Whitmer. An appeal court ruled that Trump can fire board members of an independent agency. Ooh, that's a bit spicy. That's a bit spicy. The auto pen thing is not an issue. The auto pen issue is dumb. The Federal Court of Appeals allows President to remove NLRB member for now. A federal court has allowed President Trump to remove Glenn Wilcox, an NLRB member, while it considers the case. The court decision reverses an earlier district order that directed the president to return her to the job. In the short term, the Court of Appeals decisions Wilcox will again be ousted from her seat, and the board will only have 2 active members. Undecided for now is the larger question of whether the president may remove board members at will. Under the NLRB, board members can be fired only for malfeasance or neglect of duty. They also must be given notice and hearing. But those requirements have become increasingly controversial, with some scholars and judges questioning whether they interfere with the president's ability to manage the executive branch. Fair. Especially as it relates to like the heads of the agency, right? Because these are agency heads. These are not just line employees. These are agency heads. So they're politically appointed. Now, they're politically appointed of independent agencies, but does that matter? It's like, okay. Member Wilcox challenged her removal in court. In early March, a federal district court ruled in her favor and ordered the administration to let her go back to work. The administration then appealed to the D.C. Circuit of Appeals. First, Judge Justin Walker wrote the administration is likely to win on the merits. He suggested that NLRA removal requirements were unconstitutional. He reasoned that under Supreme Court precedent, Congress could restrict the president's removal only for agencies that execute no executive power. And in his view, the board does exercise that power. The board administers labor law, so it's engaged in core executive function. Yeah, that seems pretty reasonable. Second, Judge Karen Henderson wrote she mostly agreed. While she thought the question was closer, she ultimately agreed the removal requirements were probably unconstitutional. Third, Judge Patricia Millett wrote she would deny the stay. She thought older Supreme Court decisions allowed Congress to protect heads of certain independent agencies from removal. So yeah, this basically gets to whether or not the president can fire the heads of executive agencies, which I would think so. But that's one of the things that's percolating. Exciting. How about just basic federal employees? No, not necessarily, because basic federal employees are typically protected by Title V. So we're just talking about agency heads. We're not talking about standard employees. Just the agency heads. What is this? Can he fire standard ones in bulk through a reduction in force? There are rules relating to that, but it's not what we were trying to talk about right now. So I don't really want to get into that issue because it raises other legal questions. The Ninth Circuit has prevented the Trump administration from getting rid of transgender soldiers. Yeah. So that's controversial. A U.S. appellate court, the Ninth Circuit, on Monday denied a request by the Trump administration to pause the lower court's decision blocking President Trump's ban on transgender people serving in the military. The Trump administration appealed the ruling and asked San Francisco-based Ninth Circuit to put the ruling on hold. On Monday, the three-judge panel request for so-called administration stay was denied. So he can't get rid of the transgender. In a similar case, the U.S. Court of Appeals for D.C. Circuit issued an administrative stay on lower court order blocking the transgender ban. So for the moment, he can't get rid of the transgender soldiers. Okay. That's controversial. What else? Ooh, the Indiana Court of Appeals recently met in a high school auditorium. That's kind of cool. I like that. That's cool. I like when they do kind of things like that. That's fun. Yeah, okay. So a faulty search warrant brought the Indiana Court of Appeals to a Mishawaka high school auditorium. That's cool. I like that. You know, making things a little bit more accessible to the public. So it's like we're going to hold the Court of Appeals in a high school auditorium. That's cool. I like that. Indiana Court of Appeals judges heard oral arguments at the Mishawaka High School in a drug possession case where the initial search warrant contained an error. The visit was part of an ongoing program called Appeals on Wheels. LOL. Meant to educate people around the state about the judicial system. Defense argued the initial warrant was invalid and police had no right to enter the home. I kind of want to watch this oral argument because that sounds like fun. The Court of Appeals of Indiana, second highest court, has concluded more than 400 appeals on wheels around the state. The court, normally based in Indianapolis, has traveled to all of Indiana's other 91 counties and held court in universities and law schools. I like that. The point of the program is to give people all around the state the chance to learn how the court system works. The case was heard at the Mishawaka High School in front of an auditorium full of students. Judges Elizabeth Travis, Paul Felix, and Mary DeBoer preside over the case. Tararis graduated from the school in 1980. I used to be a student at the school long ago. Student counsel president Jaden Monroe, a senior, was tasked with banging the gavel to bring and close the proceedings. Mishawaka High School Jaden Monroe asked his bailiff. That's fun. I like this case. This is fun. There's got to be video of this, right? There's got to be video of this thing. I want to watch some of this just for the lulz. I think that's wicked cool. There's got to be YouTube video of this, right? How can there not be YouTube video about this? Were only pictures taken? They didn't videotape it? That'd be lame. Aw, there doesn't seem to be any video of it. That's disappointing. I am bummed out. There's no video. That sucks. Why do I need testosterone at all if your numbers are that good? Because the numbers weren't that good before. That's the whole thing. That's the surprise. My numbers weren't that good. Now they are that good. So that's the surprise. Yeah, it's like, yeah. Was I not kind of clear about that point? I thought I was reasonably clear. I'm like, oh, these numbers were surprising to me. These numbers were surprising to me. They were much higher than I expected. They were very good. It's like, so this, even without supplementation, they were good. It's like, yeah, I thought it was pretty clear about that point, but I guess someone was confused somehow. All right, there doesn't seem to be anything else going on that I really want to react to right now. So I think we're going to conclude the stream, and then I have to figure out what I'm going to do with the rest of my day, which I don't know what I'm going to do with the rest of my day. I don't know. There's some new filings in the Karen Reed case. Of course there are. Let's see if we get to see some new filings. All right, so I have to go find the new filings for Karen Reed. Give me a second, please. Let's see. All right, what is today? March the 3rd? Or April the 3rd, rather? All right, so there's a complaint against what? Judge Kearney? What? Oh, because members of the public, they want to sue with respect to the buffer zone. I see. Let's see what else we got. A motion for temporary restraining order in the complaint. Yeah, they won't get it. And what else we got? Response to exclude testimony. Defendant's April 2nd motion, requesting the clerk's list of jurors, and a motion on the 3rd for the clerk's list of jurors. All right, so let's see if we can respond to some of these motions. Yeah, just wants a list of jurors. Yeah. Okay. So we got some other stuff that we haven't covered. We probably won't read it completely, but we'll take a look at it. All right. Defense response to Commonwealth's renewed motion in limine to exclude testimony of Garrett Wing. Now comes the defendant in the above caption manner respectfully requests this court deny Commonwealth's motion in limine to exclude Garrett Wing. The entirety of Commonwealth's renewed motion appears to be based on inaccurate premise. Defense intends to call Garrett Wing as a sur-rebuttal expert to Commonwealth's expert witness Crosby. And actually, defendant intends to call Wing as an expert witness in the case in chief and not as a rebuttal witness to Crosby. On that basis alone, the motion should be denied. As stated previously, on June 18th, the court determined that only a medical doctor could opine on medical cause of injury to a human. Till March 6, 2025, defendant therefore operated under the impression that only medical doctors are able to testify as to medical causation, including injuries caused by dog bites and or claw marks. The court's March 6 order caused defense to revisit the topic of wounds to the right arm of decedent, including potential witness experts in dog-inflicted wounds who are not medical experts. At no point did defense ever express that Lieutenant Wing is intended purely as a rebuttal witness. Rather, the court's determination on Dr. Crosby would inform defense strategy. Additionally, until the March 6 order, several questions remained about how defense would proceed relative to the Commonwealth's treatments of Dr. Crosby. In oral argument, the Commonwealth verbally stated it did not intend to call Dr. Crosby in their case in chief, intended only to call him as a rebuttal witness against the testimony of defendant's expert. The court asked, just to be clear, the Commonwealth does not intend, if I permit testimony, does not intend to call him in the case in chief. The Commonwealth responded, absolutely not. However, the court's order contains no such limitation on the scope of Crosby's testimony for the Commonwealth to call him only as a rebuttal witness. Due to the lack of memorialization of Commonwealth stipulation, defense reasonably assumes the Commonwealth could cause Dr. Crosby in his case in chief. For the first time ever in writing after receiving a report of Lieutenant Wing, its renewed motion of the Commonwealth states it intends to offer Dr. Crosby only if necessary to rebut the testimony of Dr. Mary Russell. Defendant intends to call Lieutenant Wing as an expert witness in their case in chief. Lieutenant Wing's decades of knowledge, skill, and training experience together with documented methodology qualify him as a subject on the expert of dog wounds. To cure any perceived complaints by the Commonwealth in the original report, the defendant will provide an amended report which will remove all references to Dr. Crosby. Defense expects to provide this amended report within 5 days. As defendant intends to call Lieutenant Wing as an expert in her case in chief, the discussion on page 2 of the Commonwealth's motion is inapplicable. This notwithstanding a reference to the Commonwealth's incorrect assumption, defendant intends to call Lieutenant Wing as a rebuttal witness. The Commonwealth states in its renewed motion that there's no sub-rebuttal in Massachusetts court. The statement is accompanied by no authority and is also incorrect. In fact, witnesses are explicitly allowed to testify in sur-rebuttal in Massachusetts. Therefore, even if did intend to call him as sur-rebuttal, there's no law on point. Therefore, you should deny it. Yeah, that sounds about right. That all sounds right to me. All right, and then we have a decision and order on defendant's motion to exclude testimony of Dr. Judy Welcher in the alternative request for voir dire. After review of the party submission and consideration of the 5 Daubert-Lanigan factors, the court concludes there's no reason to preclude the testimony of Dr. Welcher. Dr. Welcher has the requisite education, training, experience, and familiarity with subject matter, and the report demonstrates the methodology or theory underlying the expert testimony is sufficiently reliable. Defense raises several challenges to specific slides provided by the Commonwealth. Dr. Welcher's expert report accompanying the slides, however, indicates the information and methodology relied on. To the extent the Commonwealth seeks to elicit evidence the defendant believes is beyond the witness's field of expertise, is not supported by methodology that's commonly accepted, or relies on witness statements, defense counsel can object to the line of questioning. Will it be necessary to take evidence outside the jury's presence prior to the admission of testimony is not decided at this time. Therefore, it is denied. Now, no surprise there. And then we have a complaint relating to the buffer zone. We have some people versus the court in the United States District Court relating to the buffer zone. The Karen Reed trial has drawn significant public attention. Plaintiffs are members of the public who wish to attend, publicly express themselves near, but not on the grounds of the courthouse. Their primary concern is they wish to criticize the judge. They've been doing so since November 2024 without incident. They've been doing so peacefully. They've been doing so while the judge presides over cases in the courthouse, and neither the Sixth Amendment nor First Amendment have felt the slightest chaff. However, Judge Kearney has found pretext to shut down pretests against her. An ignoble request from the Commonwealth that an ill-defined buffer zone be declared on the streets, public walkways, public library, and private properties surrounding the courthouse. If they're surrounding the courthouse, that probably works. You know, she can probably kick them off the block, I would imagine. Judge Kearney joyfully entered the order ex parte, enjoining plaintiff and everyone else who's not subject to her jurisdiction from speaking on private property on traditional public forum. It's a lawless, ultra-virus act that violates constitutional guarantees of free speech and due process. Time, place, manner restriction, baby. Time, place, manner. I don't think so. Kearney has issued this order primarily to quash criticism, as the only protests have been documented have been the plaintiffs in this case, who have quietly held signs criticizing the judge. I'm not sure how quiet they are, but all right. To remedy the wrong, the plaintiffs bring this action against the court in their capacity in this 1983. Not a chance. The court is not, the federal court is not going to do this. Not if they're just trying to kick you off the block. Not if they're just trying to keep you off the sidewalk surrounding the courthouse. Like, this case has got a lot of attention. The buffer zone needs to be relative to the need. The need for this is particularly high in this case. The buffer zone is not dependent on what you want to say, so it's neither pro nor con. It's meant to have order around the courtroom for ingress and egress of witnesses and the jurors and so forth and so on. So this sounds like a no. It sounds like a no. If the buffer zone is as limited as they're indicating, not a chance. Prior to the first trial, the Commonwealth filed a motion to create a buffer zone beyond the grounds of the courthouse within 500 feet of the court. Is that too far? I don't know. Massachusetts citizens intervened for a limited purpose. The motion to intervene was denied, who declared that citizens had no right to intervene. Judge Kearney then issued order granting the Commonwealth's motion, asserting the Commonwealth's perceived inconvenience overcame everyone else's First Amendment rights without regard for differentiation between members of the public. Well, it wouldn't differ between members of the public. That would be weird if it did. Yeah, that doesn't make any sense. And expressly ordered, no individual may demonstrate in any manner signs within 200 feet of the courthouse complex. Yeah, that sounds pretty reasonable. Within 200 feet of the courthouse? Yeah, you're not going to win that. 200 feet? Come on, man. No. This complex includes the building and parking area. Individuals are also prohibited from using audio enhancing devices, like bullhorns and such. Time, place, manner restrictions. Yeah, no problem. Speech does not qualify as demonstrate on was not restricted. Thus, a nearby cafe could advertise a breakfast using a bullhorn and parade its menu on picket signs and placards. Yeah, because the restriction is narrowly tailored, or it's limited as it needs to be. It's only relating to people relating to the protest. And also we're concerned because there's so many of them. But we're not trying to have a generalized noise ordinance, right? So to the extent that the Sandwich Cafe can use a bullhorn, then sure, they were able to do that anyway, right? We're just concerned about the many people that are coming, which, could all have their sound amplification devices, and it might be a bit much. So no. Celtic and Bruin fans could simply honor their teams by hooting and hollering and clanging placards. In fact, commercial speech is prohibited. So that sounds a lot like we've tried to restrict this. It sounds a lot like we've tried to narrowly tailor the restriction to the need. So the thing that they say goes against it actually goes in favor of it. It's like, what is my concern? My concern is the people that are there protesting relative to the trial. Why am I concerned? Well, there's a lot of them. I'm concerned for witnesses and jurors and their ingress and egress. I'm concerned about the noise, that might interfere with the court. And also I'm concerned ultimately, of course, about, them protesting right outside the juror window and putting pressure on them. So how about a 200-foot buffer zone to deal with those problems? And these guys are like, what about the cafes? It's like, well, if they're just doing what they would normally do on any given day, why do I need to affect them? So you're not affecting their speech. That's true. So you're biased. Well, no, I'm just trying to solve the problem and just trying to tailor it to the problem. So, yeah. In advance of the second trial, the Commonwealth again moved for a buffer zone with a large area. The Commonwealth also sought specific instruction to request the police to use force to quash any dissent. Well, if you mean by force, get them outside the buffer zone, then yes. The police would be allowed to use force to not have you in the buffer zone. That would be a thing, if the buffer zone is lawful. I think what they're trying to argue is they're trying to restrict the content-based restriction. Yeah, no, I'm not feeling it. I'm not feeling it. Without an opportunity for affected persons to intervene and be heard, the judge issued order granting the Commonwealth's motions. Asserting the basis for the first motion warranted a larger buffer zone. Expressly, no individual may demonstrate in any manner, including signs or placards, within 200 feet. Okay. Again, 200 feet seems like a pretty reasonable thing, and no one can even be there to have placards and stuff because we're concerned about egress, the jury, and all the rest of it. Plus, we're concerned based on the first trial that we might need a little bit more. But she still seems like she's narrowly tailoring it. This argument is not going to work. Also, under 1983, of course, it has to be clearly established, right? Of course. It has to be a violation. First of all, it has to be a violation of your rights, which I'm not even sure this is. And second of all, that right has to be clearly established under 1983. Not a chance. Not a chance. I don't see it. For the past several months, plans to be engaging in peaceful demonstrations. Well, even if that's true, even if everyone's been peaceful up till now, it's still reasonable to take a prophylactic measure based on the size of the crowd and other concerns. So even if it's true that everyone's been peaceful, right? Riots sometimes emerge out of nowhere. So it's still pretty reasonable to take a prophylactic measure, time, place, manner restriction. For example, Plaintiff Garrett peacefully demonstrated in the courthouse with Judge Bev is conflicted and Bev's court is a clown show. Well, I certainly agree with those things. I agree with the sentiment. Such demonstrations were specifically about the judge and occurred on the trial. There were no disturbances, incidents, nor interference with the trial, but Judge Canon was apparently embarrassed and annoyed. Plaintiffs wish to continue demonstrating, including criticizing the judge, off the grounds of the courthouse, but within the buffer zone. Plaintiffs reasonably fear the judge will attempt to hold them in contempt if they engage in such demonstration. Yes, they're going to force you outside the zone. They're going to arrest you for disobeying a lawful order. Yeah. If the order is lawful, they will arrest you for disobeying a lawful order. If you don't get out of the zone. So, yeah. Plaintiffs reasonably fear the district attorney under control and direction of Morrissey will seek prosecution for a violation of the order. Probably. Yeah. So we'd like a violation. No, you're not going to get any of these things. You're not going to get any of these things. 200 feet seems like a pretty reasonable amount. 200 feet seems like a pretty reasonable amount, at least in the abstract. Maybe if they made a more specific argument, like they had maps and they'd showed me that 200 feet was in fact not reasonable. Like maybe that argument could be made. It's like 200 feet would cover all these spaces and that's too much. So maybe there was a more nuanced argument to be had. But, the solution to that probably would have been, slightly narrowing down the scope of the zone. But these guys want no zone at all. And that's not going to happen on a 1983 analysis. So they've overshot the moon and they're not going to get what they want. So that is all I have to really say about that. What's Melanie up to? Let's what's it called when you stream someone else? I forget. What's it called when you stream someone else's channel? There's a term for it. Sniping. Thank you. Sniping. Yes, thank you. Sniping was what I was looking for. Let's snipe Melanie for a little while.
Come to a unanimous decision on guilt. That's what it means. Unfortunately.
I like the posters, I have to say. I like the posters and the Grateful Dead hat. Melanie definitely representing her musical taste. I respect that.
Thanks, Katie. That's a great question. Kelly, why so many witnesses from recused Canton PD? I'm 2 hours behind, but I want to say I have qualifications in dog behavior. This, in my opinion, enables me to say why a dog would bite, not say wound. Is the dog bite well done? Well done. And we also know that James Crosby often investigates deaths where people, mostly children, are mauled.
I like the QR code with the coffee, incidentally. That's pretty cool for a QR code. Does that just go to Kofi? Where does that actually go to? I might steal that idea. Hold on. Let's see where the code goes to. Oh, it goes to Buy Me a Coffee. That's pretty cool. I like that. I might steal that logo idea for a QR code. That's pretty cool. Although mine would go to Kofi, but I like the QR code idea. I might do that.
By dogs and killed by dogs. And that doesn't happen that often, right? That's why Marie Russell said, I have more experience than medical examiners with regard to dog bite injuries because it is rare that someone dies from dog bite injuries, right? Crosby's the guy who I think helps with the investigation after someone is already dead of a dog attack. He doesn't have to figure out what happened. They know what happened, right?
I think I've got a PayPal one I can
Mighty
put
Ducks,
up.
our rights don't end. Where Bev's fear begins is called a public square for a reason. It is public. Kearney is displaying Orwellian tactics, yes, and that's been in some motions, and we have some users with Orwellian-type usernames. Thanks, Mighty Ducks. And Mange, nothing to see here. Can people on private property and buffer zones put signs on their property and wear pink? No, I don't think they can. And that's what they're saying here. You're not allowed to regulate people's private property.
That's not what they're
Tell
saying.
them what they can and not do on their cannot do on their private property.
That's not what the order is
or in their own
contemplating.
business.
Come on, Tony. That's not what's going
Great
on.
question. Thank you for your super chat. Miss Kitten Cakes, to have a juror actually want to join your defense team is wild. Thanks, Melanie. Yeah, she was outraged about the injustices of the system. Thank you for your super chat. The water in Norfolk County contains White Claw. Thank you, Canadian Gooner. You can see it from all the way up north. Gettin became a member. Welcome. Welcome, welcome. Chloe Albert's revenge is here. I think the water's fine, but their solo cups are contaminated. Well done. Ipsy Dixit. Thank you for your super sticker. Isabel Park, Melanie, they have the document in the snow on YouTube. The documentary's up on YouTube. Okay, so for those of you worldwide viewers who could not get, Isabel's from New Zealand, you guys couldn't get the documentary, the documentary that was just streaming on HBO Max and Discovery ID. Apparently it is on YouTube per Isabel. Thank you, Isabel, for letting us know that. I appreciate you so much. Hang on 1 second while I pull up the next document, the Aidan Kearney motion. Put that over there. Thanks, Isabel. My mini 67 Narnia is not involved in this show. Thank you. Anna Laura Willems, thanks for your super chat. I'm waiting to get a new aorta surgery. After the surgery, I need a 1-week coma. I will rewatch everything through your channel. I love from the Netherlands. Love to you. Prayers up for Hannah Laura. Best of luck. Sending all the healing vibes. You can do this. You got this. Thank you for letting us know so we can all pray for you. Prayer hands up for Hannah Laura. Thanks, you guys. On top, thanks for your super sticker. Velo Ange, thanks for becoming gifted a membership. Thank you so much. Appreciate you. Did you say the zip-up hoodies run large? Yes, the zip-up hoodies run very large. Because I guess it's unisex sizing, and they're super, super soft. I have two. I got the orange one, which is not really like a true orange. It's darker than it looks in the picture. And I got the whitish, like the ivory one, and I love them both. D says there's a rumor Qualin was selling illegal substances, and John
this is good.
reported. No, that is not true. That has been debunked. It is not
This
true.
QR code works.
No, it's not true.
Yeah. Okay. This
It
QR
is
code
not
works.
true. That's a rumor that was started by someone on the other side. And even Aidan has come out and saying it's Karen came out and said it's not true. So no, but thank you for your super chat. Shauna, thank you for your 10. Appreciate you so much. Isabel, Facebook will send kiwis to your channel because of me. Oh, thanks, Isabel. Love my kiwis. Baron Bombburst. Oh, that's like one of the characters in Chitty Bang Bang. Jody Mitchell is here. Not Joni Mitchell, but Jody. I simply cannot comprehend the fact that no one in media or government is asking why all this money is being paid to Brennan when they have an office full of lawyers. Yes, they have 50 lawyers. This is the hot potato case of Norfolk County. There is no conflict here. There was no reason for them to go out and hire a gun. Hank Brennan is a hired gun. They're paying him $250,000, right? It's insane. I don't know why they're not asking those questions either. They don't care about the answers, you see? Because if they cared about the answers, the reporter who went out and got the statement on a sofa from Michael Proctor's sister, Courtney, and wife, Elizabeth, when the day before it was announced that he was terminated by the Massachusetts State Police, if they wanted the real answers, they gave them the opportunity to speak out about that. Why didn't they go and knock back on their door after Judge Kearney threw Michael Proctor under the bus in her order on the motion to dismiss, blaming him for everything? Blaming him for hiding the Sallyport video, blaming him for not turning it over to the district attorney's office. She really threw him under the bus. And if I was that reporter, I'd be knocking on the door saying, do you have any response to this? You told us what an honorable man your husband was. Aren't you outraged that they would do this to him?
Where am I going to put this so that it doesn't? Where am I going to put this so it doesn't become too distracting?
Your family. No, nobody did that.
If I do it like this, does that work?
Chloe Albert's Revenge says astroturfing Ryan Reynolds literally played a professional at that in the movie Spirited, so I'm sure it's present in his wife's case. I don't know. I didn't know the term astroturfing. I'd never heard the term before.
That kind of works.
That's what I was referring to. So this is why that's why I don't cover that case. I'd never heard the term. It was the movie that he was in, Spirited. Did they call it astroturfing? I don't know. It was a term that was new to me. Love my flip-flops. Thanks for gifting 5 memberships. You're the best. Thanks, Rebecca, for becoming a member.
They'll end up blocking the mic in the normal view. That's fine. Well, I can move it. I can move it somewhere else in the normal view.
So they got my free Karen.
So I can just move it somewhere else.
Bay County, Florida against Crosby. Yeah. Bay County, Florida. There was a recent death, right? Where a child was mauled by pit bulls, and I think he was called into the autopsy. Is that what you're talking about?
Yeah.
Thank you. I'm glad you like your zip up.
I'll just put it in the other corner like that.
Canadian Gooner, Anti-Bev is a poser. Love the green hair. Bobby Leslie's Slice and Dice, now open for business, says, OMG, I had to change my name. You were previously Reed's Bite is bigger than Chloe's, and now it's Bobby Alessi's Slice and Dice, now open for business. I will allow it. I will allow you to send me $5 to tell everyone, and that is amazing. I love it. Ashley Lawrence says, my sweater came today from the wheel spin. Oh, that's right. You won. We did a giveaway. We could do a giveaway today. You guys want to do a giveaway? In a little while, we'll do another one. I'm so glad that you like it, Ashley Lauren. I'm so glad that you like it. I think we did 3 giveaways on that stream. You just have to be willing to give me your address, and I have to, and I can send you a prize. KOB, so many motions. Did she yet rule on allowing the crash daddies? She has said that they are going to be voir dired like the day before their testimony. So she hasn't really ruled on it because after their voir dire, she may say, no, they can't testify, which is insane. Because how do you know what?
Well, I think that's enough of that. She's just doing, audience Q&A. So I think that's enough of the sniping for now. But, Melanie's cool. Make sure to check her out sometime. I'm going to sign off for now, and I'm not sure what I'm doing with the rest of the day, but I'm going to try to do something productive with the rest of the day. So I'll let you guys go for now. And if something else happens, we can start another stream later. But I think that will conclude us for the moment. So I've had fun. Hopefully you've had fun. I'm going to send you Melanie's way. I sniped her. It's the least I can do. So I'll send you to her channel. Give me a second to set that up. All right, guys, I will see you next time. Bye-bye for now.